Good morning, Commissioner. Our witness today is John McClellan. Pardon me, McLennan.
You got it.
And he has not yet been sworn.
Would you raise your right hand, please? Do you affirm the evidence you're about to give in this matter will be the truth, the whole truth, and nothing but the truth?
Yes, I do.
Thank you.
Good morning. I'm going to start with some questions about your professional background and your employment history. I understand you're no longer an employee with the City of Hamilton. Is that correct?
That is correct.
Prior to leaving the City of Hamilton, you were the manager of risk management services.
Correct.
When did you start in that role?
Exact dates aren't my strong suit, but I believe I started in that role around 2012 or 13. My previous boss had retired, I think in 2011, and I was acting for some time and then eventually appointed as the manager of risk management.
Thank you. And in that role of manager of risk management, who did you report to?
When I first took over the role, I reported to financial services. I believe the title was, his name was Rick Mail, and he was, I think, director of financial services. And then there was a bit of a reorg. I would estimate around 2017 or 2018, wherein risk management began reporting to legal services.
Thank you.
Or upward through legal services, I should say.
Thank you. You affirmed an affidavit as part of the inquiry process that sets out some of your former roles at the city, and I'd like to take you through that so you don't have to assess the dates from memory. Registrar, can you bring up RVH 1017, please? And could you call out paragraph 2? So in your affidavit, which we'll come back to, you've set out various roles, and just looking at that, are those roles accurate starting from January of 1998? I see you nodding for the court reporting.
Again, not my strong suit, but I would say they're certainly in the ballpark.
Okay, thank you.
Yeah. Except I wasn't a manger.
Fair enough. Can you close out the call out, please, Registrar? So we'll come back to this document, but you'll see at the top, it is an affidavit in your name affirmed on August 22, 2022. And Registrar, can you go to the last, the fifth page of this document, please?
Emily, sorry, can I interrupt?
Yes.
If you go back, sorry, I just noticed this.
Sure. Can you go back to the first paragraph?
Yeah,
first page,
2D manager in the legal and risk management service from approximately June 4, 2012 to November of 2021, it should read.
Thank you. Thank you. Did you have any employment with the City of Hamilton between November 2021 and February 2022?
I did not.
Okay, so that's just a typographical error.
I would assume so, yes.
Thank you. Registrar, can you go down to image, if you could bring up image 3 and image 4, please. So we'll go through this later in your evidence today, but just so that we can make it an exhibit, you'll see that you signed it electronically on the 22nd day of August. Do you see that?
I do.
Okay, and you recall executing this affidavit?
Oh, yes.
Thank you. And you reviewed it carefully before you did that?
Correct.
carefully enough, maybe with some typographical errors. Thank you. I'd like to make this the next exhibit, please. I believe we're on exhibit 165.
Thank you, Council noted.
Thank you. You can close this document. Before you started at the city in 1998, where did you work?
I worked for State Farm Insurance.
In a similar role to the claims representative role that you took on at Hamilton?
Yes.
What is your educational background?
I graduated high school and then went to University of Western Ontario, where I majored in political science.
Okay. And did you move directly from school to State Farm?
No, I think there was a period of, probably, I think it was about 5 years. I waited at the keg for a long time. That's where a political science degree gets you.
Fair enough. Maybe I'll put my question differently. Did you learn the claims management practices on the job at State Farm?
Handling of claims, yes.
Okay, thank you. Turning to your role as manager of risk management services, starting really just with a little more information about that department. What is the primary function of the city's risk management services department?
The primary function, the first and foremost function, is the handling of claims. City on average receives or handles on average, but I would say between 2,000 and 2,500 claims a year, which is a pretty heavy workload. So the majority of our time is spent administrating and handling the claims. We also have the other two silos or roles would be the procurement of the annual insurance coverages and contract review, what we call compliance issues. When we, in a perfect world, we would get into enterprise risk management when we could, but we really weren't staffed or financed to flesh out that role to any great degree.
Okay. And what does enterprise risk management mean?
It's sort of a concept that developed, I'd say, at year 2000, maybe a bit before. I would compare it to the you're trying to establish risk management and accident avoidance the same way occupational health and safety has done at organizations. Everyone thinking about accident avoidance and trying to spot potential liability situations before they turn into actual liability situations. So it's really making everyone risk aware company wide, as opposed to maybe just your risk management department and maybe legal services, giving the odd lecture or seminar once a year sort of thing.
Okay, thank you.
Yeah.
Flowing from that answer, did risk management have an advisory function with other departments within the city around risk or risk management?
Yeah, I mean, we were a service division. That being said, it was generally not proactive. People, departments would come to us and say, we've got a situation here. We'd be interested to hear what risk management has to say. We occasionally might spot claims trends. More often than not, it was trip and fall situations, be it on crosswalks or sidewalks or roadways. and proactively reach out to a department, but generally departments came to us and to ask for advice.
Okay. And where you brought a claim trend to a department or a department reached out to you, what was your role in resolving the risk that you'd identified as compared to the other department?
As compared to the department that we were working with on a particular issue?
Exactly.
Well, more often than not, well, I shouldn't say more often than not. At first, because risk management kind of has their finger in a lot of pies around the city. So I think the first order of business for us would be to actually learn what, and I'll use trip and falls as an example on sidewalks, to learn, what goes into the creation of a sidewalk, what goes into the life, what is the lifespan, what goes into the inspection and maintenance. And we would receive all that information, and then through our risk management lens, and sometimes with the assistance of legal services, we would and with knowledge of developing case law or case law that has already happened, suggest that they may need to make certain enhancements about inspection periods or maintenance responses to customer or citizen complaints, that sort of thing. It was almost, I would always term it as sort of and this sounds a bit, I don't know, maybe a bit haughty, but applying a common sense lens to a lot of things that the city did, the services the city offered, I should say.
Okay. So where there, it was a suggestion to make certain enhancements or maintenance responses. Once that decision was sort of put on or that suggestion was put on the table, what role did risk have in seeing that suggestion through to implementation?
Well, we were advisory. So, what I would usually say, sort of off the cuff, is, I reserve the right to say "I told you so" if you don't act on my suggestions. A lot of times our suggestions really weren't consistent with the budget realities of a given department, which was completely beyond my understanding, I guess. We would just say, here's what you might do in a perfect world.
Okay, so am I taking from your answer that apart from providing this suggestion, or at least giving a heads up about an issue or a claims trend, that risk really didn't have any role in costing or finding funds or actually implementing?
I would agree with that.
Okay. So I think you said that the city or your department handled in 2,000 to 2,500 claims a year, roughly.
Yes, I would say, on average, it usually seemed to be somewhere between 1,800 and 2,500.
Okay, and when you say handle, that's the total number of claims that are on your that are in your department's
system.
system.
And I should probably clarify that a claim is, it is someone, putting in writing, submitting to the city. I have a problem with the city. My sewer backed up, or I hit a pothole. I've incurred damages, and I want compensation from the city. That's how they would come from citizens, and of course we would get claims from law firms too.
Okay, and when you say someone putting in writing that they have a problem, do you mean the commencement of a legal claim, or do you mean putting the city on notice?
Just, and by legal claim, do you mean statement of claim?
I do.
No, I mean, and that's a claim. We should have never called them claims, because we considered a claim someone just writing a letter to the city, not through small claims or anything like that.
Okay, I see. So anything from writing a letter to the city to actually commencing litigation against the city.
Right. And, eventually, when I first started in the 90s, we used to insist on the letter being written, being put in writing. But as things developed, we would then accept an email occasionally if it was, an elderly person or someone who really wanted to complain. We would just accept the information over the phone and start the claim that way.
Okay, so when you say there's 1,800 to 2,500, I think was your 2,400 was your range.
Yep.
That would include claims, or pardon me, notices that came into the city and never went anywhere. Is that right?
Never went anywhere in the form of they didn't develop into statements of claim or litigation. More often than not, they didn't. They were either denied with an explanation. We're not paying your pothole claim because the road was inspected. We've, with all due diligence, we've inspected our roads and maintained them. That sort of answer, or we would pay the claim if our investigation found that the city was negligent somehow.
Okay. And it would also include claims that, as you say, come through law firms. So where there's actually a statement of claim issued.
Absolutely.
Okay. And for the that first category we were just talking about, where the city would receive a notice and assess it and either deny it or pay it. Did all of that stay within the legal risk department as compared to internal or external legal counsel?
For the most part, yes. The only time outside, I shouldn't say that, because we did have outside adjusters who assisted us with our investigations. We only had 4 claim reps in our staff of 10 who actively handled claims on a day-to-day basis. So we had a roster of, I think, 3 adjusting firms who would do investigations for us. If you're talking about outside legal, there were 2 reasons why outside counsel would be used, and that would be if particular expertise was required outside of the abilities of legal services at the city, or if the insurer preferred to assign outside counsel. So if we reported a claim to an insurer, and we would do that when potential damages would exceed our deductible, which has been as high as $1 million at times, they would more often than not say, okay, this is going to go to, is usually one of 5 firms that were on their roster.
Thank you. That's helpful. So you talked a little bit about outside counsel. My question was actually focused more on your team and risk versus any lawyer, including internal city lawyers. So maybe I'll ask my question a little differently. Did the claims team within risk handle the assessment of claims more often than not, and not involving internal legal counsel?
Yes, that's correct.
Okay. So of the large volume of claims that the city was handling at any given time, can you provide some categories of the types of claims that the city would attract?
Sure. The most, I can sort of give you a top 10 list, probably. The biggest being potholes. They were the constant thorn in our side. Sewer backups, trip and falls on the sidewalk, slip and falls on the sidewalk. City of Hamilton was a I forget the terminology, but well, I guess one tier. So we handled all municipal services. So we would get a fair amount of internal claims. They would come through our office when we had damages to a city property, flooding or vehicle damages. Certainly motor vehicle accidents where people would allege that it could be potholes, it could be alleging something wrong with the traffic signals or road signs or or condition of the roadway. We had a certain amount of police claims for wrongful arrest, excessive force, police pursuits. Those would be the main categories. I don't think I'm leaving anything out. Water main breaks, when they would happen, would generally cause flooding in a neighborhood, that sort of thing.
Okay. You said that Risk handled all municipal services, so you get internal claims. And just to unpack that a little, just so that I'm clear, that's where the city wants to make a claim against the insurer for some property damage incurred by the city?
Well, the way I've explained it before is you could look at us basically as the mini insurance company for the city. We carried extremely high deductibles. The lowest deductible we've ever had is $250,000. So even when we had internal damage, like say a fire at a building or a flood at a building, generally we handled it in-house underneath our deductible. Very rarely would a property claim go to the insurer. So they funneled through risk management, even though the department may be the primary department for facilitating the repairs, it funneled through risk management for tracking purposes.
Okay, thank you. That's helpful. Yeah. You also said, you referenced the number of categories, and you had potholes, and then you had motor vehicle accidents, which might include potholes.
Right.
For the first category, what do you mean about claims involving potholes?
So we would, every year there would be pothole season. It was usually spring, or occasionally when the weather started getting cold in the late fall. But someone would be driving along a roadway, and you know what a pothole is, I think, and they would bottom out in the pothole, and it would be a flat tire or a bent rim, and they would make a claim against the city for the repair expenses that they incurred. And it was really you had no way of knowing what kind of pothole season you were going to have. And it really was completely dependent on the freeze thaw cycle of the weather. And some years we would get 500-600 pothole claims. Some years we would get under 100. We always received, generally I would say potholes were always in the top 3 of categories of most common claims.
Okay. And what about motor vehicle accidents? Any kind involving potholes or otherwise?
Sure.
What was the percentage of the total claims that were related to motor vehicle accidents?
Well, it would certainly be, I'm going sort of from memory. I don't have hard statistics in front of me. I would say motor vehicle accidents would be in the top 15 probably of most common claims. And again, very weather dependent, because most of them were related to winter maintenance.
Okay. When you say top 15,
we used to sort of joke, I was a good risk manager in the years where there was easy winters. You pat yourself on the back and say there were no motor, we didn't have a lot of motor vehicle accidents this year. But Certainly, and we wouldn't just code them as motor vehicle accidents. There were codes for ice and snow on the road, traffic signal, road design, that sort of thing. Whatever the main thrust of the notice of claim was, that's how we would code them.
Great. We will come to some coding in a moment.
Sure.
You said the top 15 most common claims.
Uh-huh.
My question had been as a percentage proportion of all claims. Can you give us some range of how many, what the percentage of total claims related to motor vehicle accidents?
I would, well, if we use a figure of let's say 2,000 claims, I would say, and this is not an exact science by any means, and those numbers certainly could be produced. Out of 2,000 claims, I would say claims of negligence against the city related to motor vehicle accidents, excluding potholes, would maybe be 50 on average.
Okay.
50, I'm not good with math, though, whatever the percentage, whatever the boils down to out of that.
Okay, thank you.
And that by no means an exact science, Emily.
Fair enough. So not a large proportion of the types of claims. Is that fair to say?
I would agree with that. Yeah.
Okay. Not being good at math myself, but yeah, 50 out of 2,000. In terms of the types of damages that would arise from motor vehicle accidents, were they more significant than the number of claims proportionally?
Well, when you weed out potholes, which very rarely involved injury, motor vehicle accidents would be a concern because generally no one would think to bring in the municipality because they are covered by insurance. They also have the ability to sue the at-fault party. When the municipality was brought in, it was generally because damages were more significant.
Right.
So they were what we called low frequency but high impact in terms of damages.
Great, thank you. So let's talk a little in more detail about the structure of the department. So who reported to you within risk management?
Okay. Well, as manager, everyone reported up to me eventually, but I had, I shouldn't say we had claims supervisor, Diana Swaby. Our senior team was myself, Diana as claims supervisor, and for the most part of my tenure, senior risk and compliance officer by the name of Jody Yarmo, who really had no involvement with claims. And underneath her, she had, underneath Jody, there was her title was claims representative, but she was really an assistant to Jody, helping her with compliance issues and contract review. For our concerns, Diana was a claims supervisor. She had 4 claims representatives and 2 risk analysts underneath her.
Okay, so those.
And there was a risk assistant as well.
Okay, so those the claims representatives and the risk analyst, that's 6 altogether, all reported to Ms. Swaby, and then she reported to you?
Yes.
Okay.
Now, and I can't say that exactly. One of the risk analysts may have been considered under the silo of the compliance officer, but it wasn't etched in stone. It was the analyst sort of provided support on an as needed basis.
Okay.
If I recall the performance appraisals, Jody did do the performance appraisal for one of the analysts, and Diana did the performance appraisal for one of the other analysts. So I think you could safely say Diana had one risk analyst underneath her and 4 claims representatives.
Okay.
Yeah.
And each claims representative, did they have their own caseload of claims?
Correct.
And did Diana also, Ms. Swaby, also have her own caseload of claims that she personally managed?
Correct, as
Okay.
did I.
Okay, thank you. That was going to be my next question. And just for a matter of clarity, I think it might come up. Ms. Swaby, I understand she went by a different surname earlier in your tenure as manager.
Yeah, she moved from Sabados to Swaby at one point.
Thank you. And so how actively were you involved in managing claims?
Well, I mean, in terms of, I had a caseload of probably about 300 claims. So I was obviously active in the handling of them. But for the most part, I was content to leave the primary oversight of claims handling to Ms. Swaby.
Okay. And when you say the oversight of claims handling, so she had her own files, then those underneath her had her files, and she provided oversight to the claims supervisors. Yeah. Okay.
Claims representatives. And, that being said, certainly, her office was right beside mine. She would, back before the pandemic, we would probably have daily conversations about claims, about the performance of the claims representatives, particular claims that were representing a higher exposure. So I would say I had a pretty good handle on the general flow and status of claims, and certainly I needed to have that in terms of reporting up to either through financial services or legal. But Diana, nuts and bolts, that was her purveyance.
Okay. And was she entirely responsible for the assignment of particular claims to particular staff members?
Primarily, yes.
Okay. So did all claims that came into the city flow past your desk at one point or another?
Well, they would come in to, more often than not, they would come into clerks, and clerks would stamp them, and they would write J. McLennan Risk, and they would come over to risk management through interoffice mail. But the risk assistant who handled the mail would look at them and say, "That's a new claim. I'm plopping it down on Diana's desk for assignment out to the claims reps." Maybe if something unusual caught the risk assistant's eyes, she might point my attention to it. But through Diana's tenure as claims supervisor, 98% of the time she would be assigning the claim. She may come to me on occasion and say, I think we should farm this out to Sedgwick, who used to be Cunningham Lindsay, or a couple of the other claim services that claims adjusting services that we used.
Okay. Did you find that would you say you had a good working knowledge of all of the claims that were being handled by your department?
I think so.
And how did you develop that working knowledge of all of the claims?
Well,
what touch points did you have with them?
Coming up through the system as starting at the bottom as a claim rep and coming up through the system. But as I said, Diana's office was right beside mine. I would fairly often look at claims reports from one of the analysts about where we were at in a given year in terms of our claims expense. I say after second quarter, I would like to look and see that we were coming in at a projected claims expense number that was at least consistent with past years, and there were going to be no surprises at the end of the year where the claims expense was much higher than it was projected to be.
Okay. But it's not that you actually had sort of working knowledge of the details of all 2,000 claims that the city was handling.
No, only in the sense that, you work at a place long enough, that, okay, there's a certain, there's going to be here, the top 5 don't change every year. The top 10 don't change every year. So it's a matter of how they fluctuated in terms of weather, or in terms of certain happenings at the city.
Okay. How did risk management keep track of claims?
We had a claim software system, which entitled Risk Master, which I think we got into that. We purchased that in 2000 or 2001. Previous to that, it was a fairly antiquated data program. Really, we used sort of spreadsheets before then. And Riskmaster was a fairly common software program used by municipalities.
Okay. What type of claims information is stored in Risk Master?
So when a claim would come in, when we were finally allowed to hire a risk assistant, her primary role was the data entry of claims. Previous to that, the claims reps themselves would do it. But you would read the notice of claim, and there were several hard-coded fields in Riskmaster that you couldn't save the claim until you had input the data into these hard-coded fields. And obviously, date of loss, all contact information for the claimant, they were all hard-coded, as were you had to post a reserve, and you had to post or you had to enter in the department, the most appropriate department, and the cause code, which I think we had a list of, I would guess about 60 cause codes that could be chosen. Probably 20 of them were the main cause codes that were used.
You said earlier that you would code in for motor vehicle accidents, for example. You'd code in motor vehicle accident and then some descriptor like pothole or.
No, we wouldn't. No, it would. You wouldn't code in motor vehicle accident. You would code in pothole.
Okay.
And the hard code would just be that it's a liability claim against the city. The cause code being pothole, ice and snow on the road. There would be an area for commentary or description too, and it was usually 1 or 2 sentences, and you would say claimant alleges tire damage due to pothole on Wentworth Street North.
In terms of that very last bit, the reference to the location, was that a requirement to put in the location of the loss?
I think so. I mean, it always was input. If it you would never find a claim where a location wasn't inputted. I don't think, Emily, that it was hard coded though.
Okay. Was Riskmaster also a location where materials that came in over time for a claim were stored?
Yes.
So it had like a filing
yes.
ability. You could see the statement of claim or the letter of notice, anything like that.
Yes, and we, at first, when we first adopted it, It really was just data management, but as time moved on, we were making a concerted effort to go electronic, so to speak.
Okay. And was your expectation that materials on a file would all be saved within Riskmaster?
I wouldn't say we were there yet. If I really wanted to, or if I wanted to really be sure that I was looking at all materials related to a file, I would look at Riskmaster and the file portion of Riskmaster. I would also want to have the hard paper file in front of me. And yeah, I was as guilty as anyone, if not completely committing to going electronic.
Okay. Is there a section in Riskmaster that that will show the status of a piece of litigation? Like, for example, pleadings closed or
No.
discoveries or anything like that?
No, you may find that in the claim, the file handler's notes, but again, if I really wanted to see where a file in litigation was at, I would look at the paper file or pick up the phone and speak to the lawyer.
Okay.
I mean, technically, yes, the claim rep should have been updating as the file unfolded, but in fairness to the claims reps and the file handlers, there simply wasn't enough time to be as thorough as possible.
Okay. Did Riskmaster have the ability to generate reports based on various fields that have been coded?
Yes, Riskmaster had I guess you'd call it a partner component called, I think, business intelligence. And it certainly wasn't very user friendly, but one of our analysts was fairly conversant with it and could run reports basically however I asked them for.
Okay, is that Mr. Chamberlain?
Gavin, yes, Gavin Chamberlain. He was a risk analyst.
Okay. Who had access to Riskmaster within the city?
Everyone in risk management, and I think that was a staff of 10. And the only other might be the HSR, that is Hamilton Street Railway, the transit authority in Hamilton. They may have had the ability to enter bus accidents as events, not as claims. So I think that our claim reps could actually go into the system and find information on a transit incident related to someone phoning in and saying that they wanted to make a claim for an injury they incurred on one of our buses.
Okay.
But certainly in terms of claim entry, it was limited to risk management services and risk management services only.
So you said earlier that most claims came through the clerk's office. Did you also receive information from members of the public through other means, phone calls, emails, that sort of thing?
Yes, consistently, people would phone the city wanting information about how to make a claim, and the customer service representatives would dispatch them to risk management services, and our risk assistant or whoever picked up the phone would explain the claims process to whoever was calling. And we would get, as society became more electronic, that would take the form of emails too.
Okay. in terms of dealing with the Red Hill and the link, did you work with other departments within the city in terms of responding to contact from members of the public, short of people actually wanting to make a claim, but rather people sort of wanting to make a complaint?
I don't, my recollection of people phoning in to risk management services is a general recollection of people making complaints about any service that the city offered. So in answer to that question, I would say, depending on the nature of the phone call, we might possibly reach out to we called them the user departments, and ask for information related to someone who called in. But for the most part, we wouldn't act on a situation until an actual claim came in. I don't know if that answers your question.
It does. Thank you.
Yeah.
So one last set of questions about sort of general practices. When a claim came in and it needed to be assessed, who was responsible for collection of documents or materials that would be relevant to a claim?
The file handler. And the reason I don't say claims representative is because Diana and myself handled files too. So it would be there would be hard coded in Riskmaster would be, I think it said claims representative. So that could be Diana, myself, or one of the 4 claim reps. And one of the analysts too, Dominic, would handle files as well.
So how did you go about collecting documents that might be relevant to a claim from within the city?
You would almost your first order of business would be to either get on the phone or get on your email and communicate with you. You get to know the city quite well over a period of time, and you develop contacts within departments, and you knew who handled certain, if it was a pothole, you'd reach out to the district investigator of a certain roads district. If it had something to do with traffic lights, you would reach out to the section of the traffic department who handled traffic signals. So you would send it by email so that you had a paper trail, so to speak, and ask for any information related to the details of this claim. Quite often, you might even send a copy of the claim along.
And then it would be up to that contact in the user department to compile documents that would be relevant.
Correct, and you would normally set a diary date, for 2 weeks hence, 3 weeks hence, depending. If you hadn't received anything back, which wasn't uncommon, because assisting risk management, really wasn't front boiler for front burner for any of the departments. But generally, they were pretty good about responding back with the information, and you would review that, and if you found you needed more information, you'd go back to them and try to flush it out.
Okay. Where a claim ended in litigation, there would be a lawyer assigned to represent the city?
Correct.
Either an internal employee lawyer or an external counsel, is that right?
Yeah, more often than not, it was internal. And usually we would have a claim on file. either a lawyer has simply just written us a letter without a statement of claim, or a citizen has written us a letter. And then eventually, if they didn't like our analysis of liability, you would get a statement of claim in. And the fact that we got a statement of claim would not automatically mean it was transferred to legal, because quite often we would simply reach out to the plaintiff lawyer and ask for a waiver. Until it would not go to legal generally until defense was requested.
Okay.
Now,
So
that being said, if it was, if it was a claim where you knew that there was no point in trying to negotiate a settlement with the lawyer, or needing to get further, if you knew that this is a denial and this is one we're going to stand on, you would funnel it right over to legal and say, might as well get this is not one where a settlement is recommended.
So where a defense counsel was appointed to represent the city, what role did the claims handler have in the litigation process?
After that point, it depended on the lawyer. Some lawyers would almost take over the file in whole, and you might not even hear from them again. Some lawyers would review the file that we sent over and say, I need more of this, or I need whatever it might be, weather history or a road inspection history, and they would ask the claims representative or the file handler to get that for them. But it was really a mixed bag of depending on how the actual lawyer preferred to stock their file, if I can use that term. Quite often they would use their clerks or their assistants. There was no hard and fast policy for the relationship.
In dealing with motor vehicle claims, did risk management provide information about the claims it had received to other city departments for the preparation of reports like the traffic safety status reports or annual collision reports or network screening charts?
No, I mean, our information, I shouldn't say that. I mean, our information, you have to remember, was claims related. So we only, any reports that we could provide would only have information relevant to someone having submitted a claim. So I guess, certain departments would want to know what their claims experience was. So in that respect, yes, we would provide that information. When I think of traffic's annual, it may have been every other year, I call it the collision report. They wouldn't seek that kind of input from us.
Was the converse true? Did you use those reports to educate yourself about the collision circumstances in the city that might be useful to your claims? Absolutely.
I found the collision report to be quite useful. It tended to give you very simple is the wrong word, but it tended to give you sort of basic information that might assist in your analysis of a file, in the way that they would rank sections of roadway, or they would rank intersections as being the top 25. These are this is not how they would phrase it, but these are the worst intersections in the city of Hamilton. And, ideally, you would have your claim and you would go to the collision report and you would say, well, this isn't an intersection that has that's in the top 25 or the top 50 of accident history incidents. So you would tend to think that this is probably a claim that we'll be able to successfully defend. To the contrary, you may find, oh, this is in the top 5. So, accident history is not going to be on our side in terms of defending a claim. Obviously, there's a lot more to it than just simple statistics, but that would sort of guide you.
Thank you. Recognizing it's hard to ballpark, how many claims did the city receive related to the Red Hill or the link each year?
Very few. I would say maybe 1 or 2.
In your affidavit that you affirmed as part of the inquiry process, you do list Red Hill based claims and link based claims that included both circumstances where an action was commenced and circumstances where there was not. And when you say there was 1 or 2 a year, that list in your affidavit, is that a comprehensive list of all of the claims that you found that related to the link and the Red Hill?
That is should be a comprehensive list. Yes.
Okay.
Emily, can I interrupt? I need to plug in my computer. I thought it was plugged in, but I just want to go to a different outlet.
We don't want to lose you, so.
Excuse me, sorry. Yes, that's better. I'm electronically connected now.
Great. Okay, let's get into the Red Hill. Turning to some more specific questions, we're going to come to some emails that you were copied on after some rainstorms in September 2013. Before we go there, the inquiries received documents that suggest within the first year of the Red Hill opening, members of council and public works staff started to receive anecdotal complaints about the Red Hill being slippery. Did those sorts of anecdotal complaints make their way to you at some point after, in 2008 or at some point after that?
I don't think I could categorize it by when. I don't think it would surprise anyone to say that there wasn't a line of anecdotal commentary about the Red Hill Valley Parkway being slippery, for lack of a better term. I couldn't tell you when, I started to become aware of that line of commentary. I suppose it could have been shortly after it opened.
Okay, and I think I might have misheard you. I think you said, I don't think it would surprise anyone that there wasn't a line of anecdotal commentary.
No, that there was.
A double negative? There was. Okay.
I don't think it would surprise. Yeah, that there was. It was. It was. It was something. Water cooler talk or anecdotal commentary that the Red Hill was slippery.
Prior to 2013, did anyone from Public Works ask risk management to be involved in anything programmatic or anything sort of high level as a proactive response to the anecdotal information that the Parkway was slippery?
Not that I recall.
Do you recall any anecdotal complaints about a lack of lighting on the Red Hill making their way to you in the first few years of the Red Hills opening?
No, I don't.
In 2013, Public Works staff started to conduct safety reviews and assessments on the Red Hill. The Trade Wind report is one piece of work that came out of some of that process. In the fall of 2013, were you aware that Golder Associates had been retained to review aspects of the pavement surface of the Red Hill?
I was not.
Were you aware in the fall of 2013 that that traffic engineering and operations had retained SEMA to conduct a safety review on a portion of the Red Hill?
I was not.
There was also subsequent studies conducted by SEMA in 2015, 2017, and 2018. Were you aware that those studies when they were in progress?
No, I was not aware.
Before late 2018, did you review any staff reports that related to safety countermeasures or anything else on the Red Hill?
Not that I recall, no.
Was it your practice to read staff reports at a Public Works committee?
No. It only if they had asked for my assistance in putting them together, or perhaps reviewing something within a report that they felt risk management might be able to add something meaningful.
In September 2013, there was a heavy rainfall incident on the Red Hill, and a number of accidents were reported in the media. Following this incident, there were a number of emails exchanged between city staff about accidents and complaints coming out of that heavy rainfall. Do you generally have a recollection of being involved in some of those email discussions?
Yes.
Okay. I'm going to take you back into the overview documents. Registrar, could you bring up OD6, page 52 and 53, please? Thank you. So just before we turn to this, can you see both of the pages that the registrar has put up for us?
Yes, very clearly.
Great. Registrar, could you call out the top of page 53, please? Thanks. So this is an email as between operations staff that there was some issues on the Red Hill due to heavy rain. The police call us saying the ramps and the road are very slippery. There are quite a few accidents. And then the author, who is a district supervisor in roads, says, I feel there's a payment problem and a speed problem. And at the end, he says, is nothing I can do to prevent these road conditions. There's no flooding. This is just the condition of the road. Registrar, can you close that down? And call out the next two paragraphs, 132 and 133. Mr. McLennan, I'm just going to take you through a few documents before I ask you some questions.
Sure, that's fine.
Ms. Blackburn, who's another person in roads, adds to the email, she says in 132, and notes, due to the super paved product they used, allowing the asphalt to last 20 to 30 years, with this mixture, it contains more liquid asphalt and small glass shards, which for obvious reasons makes it slippery when wet. And she recommends that slippery when wet signs be placed throughout the Red Hill, especially on the ramps. And then she says to maybe help alleviate the city from some potential claims and accidents. So engaging in a bit of a risk assessment herself. Would you agree?
Yep, seems to be.
And then in 133, again, this is still within roads, but it's being sort of escalated now. Roads is a big issue whenever it rains. And then the next paragraph is, can we please take the risk out of this by getting traffic to add slippery and wet signs to every ramp and along the route? And it says we're getting several collisions every time it rains, and police are asking us to do something like add sand. Registrar, could you close that down? And if you could go to the next 2 pages, please. So it gets the individuals on these emails expand from out of roads operations into traffic engineering, and in particular, Mr. White. And you'll see that at the top of page 54, paragraph 134. And Mr. Moore also gets copied in, and in 136, he says, I'm not sure where this information on Superpave is coming from, but it's totally incorrect. And then goes on to talk about micro hydroplaning and suggesting that using sand is not appropriate. Registrar, could you go to the next 2 pages, please? These are various threads of the same email discussion, but they do branch off a little. So you'll see, apologies, Registrar, if you can go to the next 2 pages at 58 and 59. So you'll see after a few days on September 25, Mr. White responds now to Mr. Scheinel, and you know Mr. Scheinel, is that right?
Yes, I do.
He's the head of roads at the time?
Well,
operations.
yeah, I don't recall his title. I know he was a sort of a senior staffer in roads, public works / roads. Yeah.
Okay. And I already mentioned Mr. Moore. Did you know Mr. Moore as the director of engineering?
I did.
And Mr. White and Mr. Mader are both in public works in the traffic engineering side.
Correct.
And this is the email at 147 that you get copied into. Registrar, can you call out the email at the bottom of page 58, please? So about 8 lines down, Mr. White says, we will also confer with risk management regarding the matter. And this is after he suggests doing a collision history of the entire link Red Hill. And then at the bottom of this, he says, road staff have commented that erecting signs will reduce our liability. I'm not certain that is actually true and wonder if we actually have any claims relevant to the road conditions, and we'll pass this information on to John, to you for comment. Do you remember receiving this email from Mr. White?
I remembered the email chain, yes.
Okay. Registrar, can you close this down? And is this the kind of circumstance where user departments might come to you for your information and expertise about the claims history on, in this case, the Red Hill?
Yes, it is.
So not unusual that a user department might reach out for you to you for this kind of information?
No, not unusual. Not all that common, but not unusual.
Okay. Registrar, can you call out paragraph 149, please? So you respond off the top of my head, I would say there is not a significant claims history for slippery conditions on the Red Hill, certainly no more than any mountain cut, if I can call it that. You go on and we'll go through this email in a moment, but just stopping there, did you consult with anyone prior to providing this response?
No,
Had you previously dealt with any claims for slippery conditions on the Red Hill?
I couldn't say now. I don't believe so.
Okay. You mentioned a mountain cut. Do you mean the graded roads that traverse the mountain in Hamilton?
I do.
And did you have some understanding or impression that mountain cuts might be different from a claims perspective or an accident perspective than flat roads?
Yeah, and I think that comes down to the common sense lens that we tend to look at things through in risk management. Any graded road or a roadway that is on a grade is certainly more susceptible, I think, to being slippery. Again, I don't like to use that term, but being slippery when it's wet.
You wrote that you copied Gavin Chamberlain to run a locations-based report in Riskmaster. So
Correct.
We talked a fair bit about Riskmaster. What can you explain here what information a location-based report would provide to be responsive to Mr. White?
Sure. I would either have spoken with Gavin or sent an email, which would have said, I probably would have laid out the basics of there's some concern about the condition of the Red Hill. Can you run me a claims report for vehicle accidents on the Red Hill using these cause codes?
Did you have confidence in the coding in Riskmaster that would rate that? Did you have confidence in Riskmaster that location-based report would capture all of the claims on the that occurred on the Red Hill?
I did. He would have. Again, I'm not the best at explaining this type of computer technology, but he would have run the report through filters of cause code and through filters of location. So it would have captured any claims in our system that happened on the Red Hill.
Not just those that suggested slippery and wet conditions?
Correct.
In the next paragraph, you write, what we do have is a situation of which we, the city, are aware, and also the general public. In the event of a serious action in the future, this experience will be cited, and the allegation will be, quote, we knew of the problem and ought to have done something about it, end quote. Lawyers love to use the word, quote, ought, end quote.
It's my apologies for that. It's not really a slight, but I guess it could. It sort of sounds like one.
What issue or situation, you say, what we do have here is a situation. What situation were you referencing of
Sure.
which the city was aware and the general public was also aware?
Well, my primary concern as the risk manager for the city of Hamilton was protecting the city against exposure, liability exposure. And certainly anecdotally, and I think Gavin's statistics would come to bear this out, anecdotally, I knew that there was not a significant accident history in terms of claims on the Red Hill Valley Parkway. But, having been in the game long enough, I knew that if an accident were to happen in the future, this type of commentary, this type of perception of the Red Hill Valley Parkway would have an adverse effect on the city's ability to defend the claim. And again, when I use the word ought there, but I certainly had read a number of judgments, some against the city and some just in researching case law that would say that the municipality was aware, or it seemed that the municipality was aware of a certain situation and it ought to have acted on it. So my warning to staff here is that this is a situation that you might want to consider, because even though there's not a significant claims history here, doesn't mean that there's not exposure. Does that make sense?
It does. So
Yeah.
You said signs primarily serve a prevention purpose. People may read them and slow down. And as for defending liability, signs don't count for much, but the downside of not having them is always much harsher than the credit for having them.
Correct.
The reference from the roads operations staff were to put in slippery and wet signage. Did you have any understanding of the requirements related to the use of slippery and wet signs when you sent this email?
You mean technically in terms of, the manual of traffic operations?
Yes, that is what I mean.
No, certainly not. And I would, my expectation would be that the people in Public Works would have that knowledge.
So you were making the risk-based recommendation or suggestion, and then you'd leave it to Public Works to determine whether it was feasible to implement or appropriate to implement. Is that right?
Correct. And had they said they wanted to put one up every 10 feet, I wouldn't object to it. But my recommendation was what it was. I certainly had no technical knowledge of what was required.
And that's common with your user departments. You make a recommendation and then they have to assess the feasibility and technical aspects of that. Is that right?
Yes, correct.
At the bottom of this email, you say, if the super paved product really does produce a slicker surface when wet, I would be curious to see what other municipalities are doing about it. At this time, did you have any knowledge of the pavement, which was SMA, that had been used on the Red Hill?
No knowledge at all.
Did you have any knowledge of other super paved pavements?
No.
Did you have any knowledge or impression that super paved pavements were slicker when wet than other pavements, apart from reading through this email chain?
Apart from reading through this, no, not at all.
Did you contact any other municipalities to ask what they were doing about the use of super pave?
I did not.
In writing that statement, were you suggesting that Public Works should do that, or were you taking that on as a task?
Well, it is a vague sentence. I wouldn't have thought to have taken on the task. That would be, I guess, a roundabout way of me saying it might be wise to see what other municipalities are doing. That being said, there are not a lot of situations in any municipalities where there is a roadway similar to the Red Hill Valley Parkway.
Registrar, could you close the call out and go to page 60, please? And if you could call out paragraph 151. So Mr. Moore replied to you and to others from the email we were just looking at, and he indicated that as part of the ongoing pavement monitoring for asset management purposes, we have skid resistance we will have skid resistance testing completed on both the link and the Red Hill. Stopping there before we go to the rest of this, his email. At the time, did you have any experience with friction testing or friction results?
No, none at all.
Were you aware if any friction testing had already been done on the Red Hill?
I was not aware.
Mr. Moore goes on to say there is a standard by which we can report on the relative level of resistance and by which we can gauge the performance of each mix and road surface. Stopping there, did you understand that friction testing would demonstrate, pardon me, let me try that again. What did you understand that friction testing would demonstrate as it related to wet weather slipperiness?
Well, I would have at the time, I would have read this and thought, well, good. They're going to do some sort of testing, and which might give them some idea of the veracity or the validity of the slippery commentary.
So beyond that impression, did you have any sort of understanding about what a friction test might show as it related to slippery?
I had no idea how they would go about doing it. I presume, I had read enough engineering reports in my career to know that at some point they possibly could be boiled down to layman's understandings, which is usually what the conclusion or summary portion of a report would suggest. So in terms of hard statistics or technical language, I would be non-conversant.
Okay. Mr. Moore goes on to say this should be sufficient for any due diligence required, eliminating the ought to have knows, as well as dealing with the we think it is slippery issues. And so did that provide you with some assurances or at least understanding that the city was going to obtain some sort of report that might be useful if there ever was a claim on the Red Hill?
Yes, it would have. I would have been relatively pleased to read that.
Mr. Moore says, I'll let you know when we get this. Did you expect that Mr. Moore would keep you apprised of or at least advise you of the results of the testing?
Reading that, I would have thought so, yes. But it's not unusual to have people say they will follow up and it doesn't happen. But reading that, I would have thought, okay, good. That'll be interesting to read once it comes in.
Did he let you know when he got friction testing completed?
No.
Did he provide you with a copy of the results?
No.
Did you follow up with him at any point?
I did not.
Did you discuss friction testing on the Red Hill or the link at any time with anyone at the city after this email exchange and before late 2018?
I don't believe so, no.
Registrar, you can close the call out. You may recall I referenced in Mr. White's initial email where he included you getting a claims history review completed. Do you recall having any discussions with anyone in traffic engineering and operations about a collision review that Mr. White said they would complete?
Not specifically, no.
You say not specifically. Do you have some general recollection?
Well, I'm looking at what Martin, that is what Mr. White has written here. So certainly there must have been at least an ask for claims history relative to some report that they were planning. And I presume we would have provided it, but I do not recall any further involvement or discussion about a report. And I don't recall a specific report going to council or coming to my office or through circulation or for commentary, other than the annual or semi or biannual reports that traffic put out.
Would you know what a collision review would look like what that would include? Is that a phrase that is known to you?
Only in the obviously it's going to be some sort of analysis of a collision history at a specific location. I don't know if that's a technical term where the parameters are consistent, or if it's something that would be created within traffic of their own design.
Did you have some familiarity in reviewing collision reviews? That is the analysis of a collision history at a specific location?
Only through the review of the collision reports that traffic routinely produced.
Okay, so not anything.
My expectation would have been that had they branched out to something specific to a specific segment of roadway, it would probably look somewhat like their annual report.
Fair enough. I understand that presumption. Did you have any experience in traffic engineering and operation creating a tailored collision review for a specific location? Had that been the kind of work?
No experience, other than providing the claims history, and those reports, they were created between Gavin Chamberlain and myself.
Okay, but no experience receiving from traffic operations a collision history.
No.
Okay. And you don't recall any discussions with anyone in traffic operations about the particular collision review that Mr. White mentions in his earlier email?
No, I don't.
Thank you. Registrar, can you go to page 83, please? And can you call out, could you bring up page 82 and 83? And could you call it the bottom? Actually, I think it's fine. I think we can read it at 214. In December of 2013, Colleen Crawford, law clerk at Shillington's, emailed Gary Kirchnoff, who was in traffic, and Ms. Swaby and Mr. Shillington, and she said she provided some details of 3 collisions in 2011 and 2012, and wanted to inquire about who should be produced on behalf of the city in these 3 actions. So just stopping there, was Shillington's one of the law firms on the roster of external counsel? You said there was a handful earlier.
Yeah, they would have been a firm approved, I guess, if you will, by the insurer to handle litigation on behalf of the city.
Okay, you're not copied on this email. Did Ms. Swaby advise you at that time that Shillington's was looking for an appropriate deponent?
I don't recall her doing so, and that wouldn't be unusual. I certainly had every confidence in her ability to handle anything that came up on a given file.
So you say that wouldn't be unusual. In the usual course, she would not raise with you issues of requesting deponents in proceedings?
No, she would, as being more hands-on with claims, she would have a better understanding of who would be an appropriate deponent. Doesn't mean we wouldn't talk about it. However, it certainly would not be unusual for her to not consult me.
Registrar, can you go to page 85, please? And if you could pull out 223, please. Mr. Kirchhoff writes back to Ms. Crawford, my director advised me today that due to the complex nature of these claims, which cross 3 different divisions, he'd like to set up a meeting. And Mr. Kirchhoff references Mr. Moore, Mr. Mader, and Mr. Scheinel, so 3 different departments within Public Works. And then a point person would be determined. Registrar, could you close that down? And could you pull up page 86, please? Could you turn now, Registrar, to page 98, please? And if you could call out 256. And Ms. Swaby follows up with some people in construction about contract documents that Defense Counsel raised. Is this the kind of task that Ms. Swaby would have raised with you either before or after completing it?
No, not necessarily, no.
Registrar, you can close this down. And I'm noting the time. I'm about to move on to another topic. Commissioner, would this be an appropriate time for us to take our morning break?
It would be. We're just about, let's take 15 minutes. We'll come back at 20 past 11.
Thank you.
Stand adjourned until that time.
Commissioner, may I proceed?
Yes, please proceed.
Thank you. We are going to turn now to 2017, so we're going to jump forward a fair bit in time. Registrar, could you call out HAM 26216, please? Thank you. And just for ease of viewing, can you call out the content of? Thank you. So we're in 2017, and this is from Monday, July 17, 2017. And you, in a subject line, RHVP article, email Ms. Swaby, not all bad, and then a link to a hamiltonnews.com website, which I believe is the Hamilton Spectator. Highway traffic tragedies. Why are there so many crashes on the Red Hill? How did this article come to your attention?
I don't know specifically. Can you hear me all right?
Yes.
Okay, good. There was a service within the city that I think from the city manager's office that would circulate media articles concerning the city to probably managers and up. That's probably how I received it.
Were you a regular reader of the Hamilton Spectator?
I was not a subscriber, but certainly in the form of that service, yes. Anything related to the city, I would generally read with interest, even if it necessarily didn't have to do with claims.
Did you ever use website alerts like Google Alerts to have topics brought to your attention?
No.
Registrar, can you close this down? And can you, actually, before we leave this document, I don't believe that this is in the OD, nor yet an exhibit. So I'd like to make this the next exhibit, which I believe is 166.
Noted, Council. Thank you.
Thank you. You can close this down, Registrar, and if you can bring up HAM 52704, please. This is a article that has the same title as the link that you sent to Ms. Swaby. Registrar, can you bring up the next page as well? It may look different in terms of form. Did you review this article in order to say not all bad?
Yes, I did.
Registrar, could you call out the first paragraph of the second page? Exactly, thank you. The first line of the article says the Red Hill had more than twice as many crashes than the connecting link over the last 5 years, despite lower traffic volumes. Was that news to you?
Yes, I would say that would be news to me.
Was it surprising, that statistic?
Well, I think I would probably look at that in a little different manner than a lot of people would, with knowledge of the link and the Red Hill, the link being flat and straight, and the Red Hill being on a fairly significant grade and with curves, and despite having lower traffic volumes than the link, certainly high traffic volumes relatively speaking. Twice as many would catch my attention, but it wouldn't cause me to, go, holy cow.
By 2017, at least in terms of the date of loss, it looks like there are 13 claims that by 2019 you've identified and are contained in your affidavit for the Red Hill. And there are 3 on the link. Is that so? By 2017, did you have a sense that there was not only more collisions on the Red Hill as referenced here, but also more claims?
It stands to reason that I would have had that understanding.
Did you personally have a carriage over any of the claims related to the Red Hill or the link?
No.
Do you recall, did Ms. Swaby have carriage from the claims perspective, have carriage over all of the Red Hill and link matters?
The best of my recollection, she would have had carriage of all of them.
Was that by coincidence or by design?
By design.
Registrar, could you close the call out? And if you could call out the 5th paragraph down, please. Actually, Registrar, could you close that call out and call out the 4th and 5th paragraph together? So there is a rumor and speculation about the Red Hill being slippery, which the author says has plagued the Parkway since it opened in 2007. And now the city is planning to repave the road surface starting next year. Do you recall otherwise being aware of the city's plans to repave the road surface in July of 2017?
I don't recall. No, this would have been my first knowledge of it.
Do you, sitting here today, have a recollection that reading this article was the first time that you learned that?
That would be my best guess.
Okay, fair enough. The article goes on to say the city has done limited friction testing on the road, but refuses to make the results public, saying only that they were ultimately inconclusive. By mid-July 2017, were you aware that the city had otherwise, not from this article, were you aware that the city had done limited friction testing on the Red Hill?
I would say no. Obviously back in 13, at that time, I would have had some knowledge of the consideration of friction testing. But I doubt very much that I would have related back to 2013, when I read this article.
Prior to the Inquirer being called, or perhaps I'll put it this way, prior to late 2018, did you understand that skid resistance testing was the same thing as friction testing?
No.
Registrar, you can close this down. If you could call out the last 4 paragraphs at the bottom of this page. The article it continues, we've jumped over some, but it continues that 2015 engineering report found crashes when the road is wet were inexplicably going up, not down, and recommend that the city study friction. Did reading the reference to the 2015 engineering report prompt you to contact anyone to obtain a copy of that report?
No.
by sending it to Ms. Swaby, did you anticipate that she would go through and assess whether there was anything contained in the report that might be useful on the litigation matter she was handling?
By forwarding it to her, I would have expected that she would read the article and apply anything within the article that she may not have been aware of to her file handling.
The article again references at testing friction. It says later that year, but the results were never made public. There is no official report, Moore said, only an informal chart sent in an email in December 2015. The friction testing was not fulsome and the results were quote unquote inconclusive, he said. But instead of doing further testing as recommended, the city decided to repave. Did you have any concerns from a risk perspective about this chronology of events, friction testing that were, results were inconclusive, and then a decision to repave?
Well, I think I would have found those last two paragraphs to be somewhat comforting to risk concerns that I might have had. First of all, I certainly had a lot of confidence in Mr. Moore and his staff. I am not scientifically or mathematically gifted, so I'm not. The discussion of friction testing would be a very vague concept to me. So, knowing Gary's reputation as a very talented engineer, and as someone who had the confidence of people that I respected very much, that being Jerry Davis and Chris Murray, my expectation was that whatever he was doing to analyze friction or grip or a slip factor on the Red Hill Valley Parkway was sufficient. And if they're going to go ahead and repave, then that seemed to render the argument concluded. I think that's what I would have thought reading those last two paragraphs. And again, Diana being the file handler of the Red Hill files, I would, obviously this article would be of interest to her, and B, my thinking is that she at least would have a file handler's / layman's knowledge of the reports that are referred to within.
Thank you. Registrar, you can close this call out. And if you can go, pardon me, to the next page. And if you can call out the first 4 paragraphs, please. Thank you. So this is further quotes from Mr. Moore, following from what we were just looking at. And he says, all we got was an indication we should do further work. It was moot when we decided to go ahead with repaving. And so is that part of the comfort that of the risk concerns you would have otherwise had?
Yes.
The article goes on to say the city refused to share that chart with the Spectator. And Mr. Moore is quoted as saying, no one ever releases that type of information because it's the first thing anybody would use in a lawsuit. On that quote, did you turn your mind to the fact that friction testing results might be producible in litigation?
No, I don't. That wouldn't have occurred to me at the time.
Okay. Reading this, did you agree with Mr. Moore that no one that with his strategy not to give information to the spectator because it's the first thing that anyone would use in a lawsuit?
Well, I wouldn't necessarily agree with his phrasing. I do understand, what he was trying to say. It's very hard to say what I was thinking reading this at the time. I probably had a bit of a chuckle at first over the statement, but what Gary is saying is that only engineers are really capable of reading and analyzing this type of thing, and it certainly could be construed however the reader wanted to construe him, given his earlier comments that the findings were inconclusive. I don't think at the time it would have occurred to me to consider privilege as it relates to the claims that we already had. Even in forwarding that to Diana, I don't know if in my mind I was thinking, well, Diana will be able to comment on privilege. It was forwarded to Diana as, she has considerably more knowledge about the claims than I do. So I will leave it to her to deal with any areas of concern in this article.
From a risk management perspective, did you see the difference in having a publicly available document given to the media versus a document that the city might have to produce in litigation?
Well, I understand the difference, yes. And I would imagine, if let's just say the Spectator kept pressing Gary, I would imagine that would then be bounced over to legal to consider the response, not risk management.
Thank you. You can close this, Registrar. So this is quite a lengthy article. It references the deaths of 2 young women in 2015 and medium barriers, a number of aspects. I won't make you sit here and read through the whole thing to answer this question, but of course, if you need to, you can. My question is this: you said to Ms. Swaby, not all bad. What did you mean, not all bad?
Well, my general perception of the Spectator in any article about city performance, city services, happenings at the city, is that they tend to have a decidedly negative narrative to them about the performance of the city and how the city was possibly or under servicing its citizens. It seems like, and I don't know if that's a product of media in general. People may tend to prefer to read negative stories about their local government as opposed to many good stories that could be told about local government. So that sets the scene, I think, for my overall opinion of how the Spectator reported on city business. However, reading this, I didn't find it to be as unbalanced as I would have expected. It references inconclusive findings, and it quotes Councillor Marula. I think at some point it references the fact that the use, the traffic flow is much higher than anticipated when originally designed. And it references driver behavior, and it references the fact that there are no absolute answers here. So that was It took that to be not bad.
Okay, thank you. Registrar, you can close this document. Following from the email, that email that you flipped to Ms. Swaby, do you recall any discussions with her about friction testing results being relevant to her Red Hill claims?
I do not.
Did she tell you, and we're in July of 2017, so let's say for 2017, did she tell you that defense counsel at Shillington's in one of some of the Red Hill cases wanted to obtain friction test results?
I don't recall her doing so, no.
It appears that Shillington's was prompted by this article to ask about friction test results. Does that assist with refreshing your memory if Ms. Swaby advised you about that?
It doesn't refresh my memory, no. And I'm not saying she didn't. I'm saying I don't recall.
Okay.
Yeah.
Did she advise you in 2017 that Mr. Moore had sent a copy of the Tradewind report, which you'll later review, to Shillington's in August of 2017?
I would give the same answer there. If she did, I don't recall it. It's quite possible that she did.
Okay. And we're going to come back to that as we move through the narrative. So I take it that those answers about not recalling if she advised you about this, those are all for the period of time in 2017. Is that right?
Correct. Correct.
Registrar, could you call out HAM 64357, please? We'll get into the content of this, but this first page, you'll see this is a letter from Shillington's dated January 31, 2018, and it's addressed to Ms. Swaby, and it is three pieces of litigation, Mello, Lee, and Barlow. Were you generally familiar with these three pieces of litigation in January of 2018?
Certainly Mello, yes. The other two, not as much. I would know them by name, and I would know they were related to either the Link or the Red Hill.
Would you know, did you have enough of a working knowledge of the details of these claims to know which Parkway they were related to, the Red Hill or the Link?
Probably at the time. I wouldn't say that I do now.
Fair enough. Registrar, could you bring up image 2 and 3, please? Actually, just image 2, please. Have you had an opportunity in preparation for today to review this document?
Yes, I have.
Okay, then I won't take you through all of it. It's fairly lengthy. It starts off at the top, City of Hamilton records. Registrar, could you call out the first 3 paragraphs under the solicitor-client privilege? Sorry, all of them from City of Hamilton records on. Yeah, that's perfect. Thank you. So at this under this heading, City of Hamilton records, Shillington's, and it's Mr. Thompson at Shillington's, says that he'd received voluminous productions from the city in response to requests for relevant documentation. And then says it's difficult to separate the pre-accident and post-accident complaints and traffic tasks pertaining to the Link, as many of the studies were over a lengthy period of time. And then it says, to further complicate matters, certain engineering studies commissioned prior to the accident were never submitted to council due to the deficiencies of calculations. Overall, the results of the post-accident traffic engineering reports do not raise concerns regarding the design and operation of the Link. Interoffice emails and buried reports, however, do raise issues that will have to be addressed in order to successfully defend these actions. So I'm going to close the call out, please. So I wanted to provide you with that context just so that you can see that there's reference to the link, and at this point, not to the Red Hill, and that there's reference to an overall comment from Shillington's about issues that will have to be addressed in order to successfully defend these actions. So with those 2 points in mind, did you review this letter when Ms. Swaby received it?
I don't recall doing so, no.
More generally, when would Ms. Swaby escalate a reporting letter from defense counsel to you? In what circumstances?
Well, that would be a very general statement for me to make. Certainly no hard and fast rule. You know, I would say when she wanted advice or direction, which wasn't very often. You know, she certainly, and not just in matters of the Red Hill. You know, I had every confidence in her ability to handle any type of file, and she was a former law clerk as well, and was very highly regarded at legal services. So, you know, I certainly would never question her ability to handle things appropriately or by best practice. And I, you know, she had a very long leash when it came to handling files without running stuff by me, and it's its approach that worked very well. I think overall we did a very good job handling files. You know, that being said, you know, she may come into my office and talk about a file on a slow day. There was just no hard and fast rule about what we might discuss on any particular file.
Okay. And where there was defense counsel assigned, as here with Shillington's, did you expect that defense counsel and Ms. Swaby together would assess whether there might be a significant issue that should be escalated to you?
Oh, absolutely. Like I said, I don't recall reading this, but reading it at this point in time, thinking back to how it would have been handled, I can certainly see Diana addressing it as it should have been addressed, and not necessarily thinking she needed to discuss it with me.
Registrar, could you go to image 5? So at the top of this page, there's reference to friction testing survey summary report, and it references the Tradewind report, and that Mr. Moore advised that the city commissioned the report as it was considering repaving options, and that testing confirmed that the friction values on the link were superior to the Red Hill. It goes on to reference a bit about the measurements, and really with a focus on the link being comparable or above the relevant UK investigatory level 2. And then there's a notation that the friction report did not go to counsel, spelled as legal counsel in that case. So Registrar, can you go back to image 2 now? So I think that provides a bit of context for that call out we were looking at before. Overall, the results of the post-accident traffic engineering reports do not raise concerns regarding the design and operation of the link. Inter-office emails and buried reports, however, do. So it does, at least as I think you can read image 2 and 5 together, Shillington's is not raising a concern about the Tradewind report as it relates to the friction values on the link. But this evidentiary issue is recognizing it's hard to say in hindsight. Is that the kind of evidentiary issue that you would expect Ms. Swaby to raise with you?
No, not necessarily. you know, we've had many discussions over the years, not just between Diana and myself, but with anyone representing the city, that you know, the biggest challenge that municipalities face, given the volume of work that they do, and given the amount of documentation, and given the amount of hands that touch everything, the biggest problem faced by municipalities in defense is one of evidence. So I wouldn't, this wouldn't represent anything particularly unusual, I wouldn't think, in the analysis of a particular claim. I would question the use of buried. I think that's probably a misnomer, but I didn't, you know, obviously I didn't write the report, and I'm only seeing it this many years later. But buried reports could mean reports forgotten about, as opposed to purposely buried.
Thank you.
Mr. you'd have to ask Mr. Thompson exactly what he meant, and if he could recall correctly what he meant by buried. It's a strange word to use.
It is a particular word to use, yes. Moving on, Registrar, you can close this and you can go to OD9A, page 13, please. And if you could call out paragraphs 18 and 19 together, please. So we've moved forward in time again, but we're still on the same topic of the Shillington's retainer. In May of 2018, Ms. Crawford forwarded an email that she received from Mr. Moore in August of 2017 to Mr. Moore, and copied in Ms. Swaby. Part of that email was an attachment being the Tradewind report. And Ms. Crawford was directing her email to Mr. Moore, she said, "We're in the process of preparing the city's affidavit of documents with respect to a litigation matter involving a median crossover on the link. And plaintiff's counsel has specifically asked us about friction testing. We will likely need to produce a copy of this report in the city's affidavit of documents, and she's asking to confirm if the report has been presented to council, and if so, to provide materials." And Mr. Moore replies, "No, this report was never reported to council." Registrar, you can close that down. So recognizing you were not copied on this email exchange, did Ms. Swaby raise this email exchange with you in May of 2018?
Not that I recall, no.
Is this the kind of information that there would be a report that would be provided, an affidavit of documents that had not been provided or presented to council? Is that the kind of information that you'd expect Ms. Swaby to escalate to you?
No, I mean, it's very, to imagine that everything that the city produces in any affidavit of documents being reviewed by council is pretty far-fetched.
Fair enough. There's that reference to plaintiff's counsel specifically asking us about friction tests. By May of 2018, were you aware of any other files in which plaintiff counsel had raised questions of friction test results?
No, I was not.
Registrar, can you go to page 118 of this document, please? And can you call out 295 and 296, please? So we moved forward again in time to October of 2018. And Ms. Sabot emailed Ms. Edwards and you under the subject line pavement. Do you at this point, by October of 2018, you report to Mr. Sabot, is that right?
Correct.
And were you familiar with Ms. Edwards?
Oh, yes.
So Mr. Sabot says, FYI, and in relation to a recent discussion Debbie and I had over consultant or drafts of reports studying the surface of the Red Hill Expressway. So just stopping there, did that prompt you to recall either the article that we looked at or the discussions with Mr. Moore in 2013 about studying the surface of the Red Hill Expressway?
I don't believe it did. No, I couldn't say, but I don't believe that it did.
Okay. Mr. Sabot says, I wonder where the numbers for the Red Hill would put it in comparison to international standards in the link below. And then he directs a question to you. Is your recollection the same as mine that plaintiffs' counsel in recent years have been aware of or requesting information on the RHE studies as a result of some discussions at city committees or in the press? So at that time, was that your recollection that plaintiffs' counsel had been aware of or requesting information about the Red Hill or about studies on the Red Hill?
Well, I don't believe I responded to Ron's question, which probably means that I didn't recollect. I really can't say for sure. What I will say is, having read these documents, I was happy to see that the Tradewin report was produced.
You mean later in time?
I mean, to Shillington's.
Oh, I see. Okay,
Yeah.
Thank you. And that's your hindsight.
I don't remember this particular email, and it wasn't uncommon for Mr. Sabot to write this type of email that sort of, it sort of lent itself to answering or not answering. If I didn't answer, I would say that it didn't twig anything for me.
Okay. Do you recall having discussions following from this email exchange with Ms. Edwards or Mr. Sabot about consultants or drafts of reports studying the surface of the Red Hill?
No, I don't.
Okay. Registrar, can you go to page 147 of this document, please? And if you can call out 344 and 345. So we've jumped forward again in time. We're now in November of 2018. And Ms. Edwards made some handwritten notes, which are transcribed here. And then the following year, she summarized those the handwritten notes into a paragraph. So there's two different versions of basically the same information. So you'll see that Ms. Edwards in 344, it says 11, 12, 18 TC Gord McGuire. Were you familiar with Mr. McGuire?
Yes. What does TC mean? That was plaguing me last night.
Telephone call?
Ah, okay. Thank you. Yes, I'm familiar with Mr. McGuire.
Thank you. And her notes say, Gary said sent info over to Diana about 2 years ago. Report looked at UK standard. There is no standard in Ontario. Report is a bit misleading since not binding. Gary doesn't recall receiving any response. John McCullen is aware. Do you have any information about, or did you have any information or awareness before November 12, 2018 about any of the information that is contained in this note?
I don't think so. I've sort of been puzzled as to what Debbie meant by John McLennan is aware. And I don't know what information she has provided on that, but my analysis or my interpretation would be Debbie must have informed me of what she has explained in this, the information that is in this transcription, if you will.
Do you have a recollection of Ms. Edwards informing you of this on November 12, 2018?
No, but I mean, it wouldn't be unusual to have had a discussion with her about it. I do not have a specific recollection.
Okay. And you don't have a recollection of what details, if any, she provided to you?
No.
Registrar, you could close this down. If you can go to page 151, please. Thank you. If you could call out 357, please. So this is the next day, the day after those notes that Ms. Edwards made. Actually, sorry, stopping just before we get into this, Registrar, you can close the call out for a moment. Where it said that you were aware, is it possible that those notes reflect Mr. McGuire telling Ms. Edwards that he had made you aware? Maybe I'll do my question differently. Did you have a discussion with Mr. McGuire in November of 2018 about any of this information that Ms. Edwards puts in her note?
Not that I recall, no.
Okay, thank you. Registrar, you can open that call out for 357, please. So on November 13th, Ms. McNeil, Berdina McNeil, emailed you attaching a copy of the trade wind report. And she says, I dropped by your office this morning to speak to you about the attached report. There is currently an FOI request that the city is having to respond to, and this looks to be a responsive document. Can we chat? Do you recall chatting with Ms. McNeil on November 30th?
November 30th or 13th?
Pardon me, 13th.
Yeah, obviously I don't remember the date. I remember at some point around this time having a face-to-face conversation with Ms. McNeil.
Okay. So looking at the email, she attaches a copy of the trade wind report. Did you review the report when you received this email?
Oh, I definitely would have.
And did you review it before you met and spoke to Ms. McNeil face-to-face?
No.
So the first discussion with Ms. McNeil, you were, you didn't have the opportunity to have digested the information in the trade wind report.
The first copy I received of the trade wind report would have been from Ms. McNeil.
Okay. And so my question is, when you then, you recall speaking to Ms. McNeil, but you spoke to Ms. McNeil before you had the opportunity to read the report?
I would expect so, yes.
Okay. Had you had any discussions with Ms. Edwards, Mr. Sabot, Mr. McGuire, or Ms. Swaby about the trade wind report, even if you hadn't received a copy of it yet before this time?
Certainly not with Mr. McGuire. It is quite possible that I had discussions with Debbie, Ron, or Diana about the trade wind report now that it sort of was a hot topic, if you will.
But you don't have a particular recollection of doing that before receiving a copy of it?
No, I don't.
Ms. McNeil references an FOI request. Were you aware before receiving this email that there was an FOI request that legal was dealing with?
I don't think so, not to my recollection.
Does risk generally have a role in FOI requests?
Not very often. Occasionally, we would get requests for our file contents on a particular file, and it was always sort of confounding to me, having to produce the records and my view was always that it was information prepared in anticipation of litigation. I always thought it was something that I shouldn't have to forward to FOI, but basically you always copied your file and sent it over, and I was never quite sure as to what became of the contents after I sent it. I was never sure what went out and what didn't go out, so it was always a bit of a mystery to me. But the only time I would get involved would be a request for what is in our files, our claims files.
And when you say when those sorts of requests came in and you say you'd copy the file and sent it over, do you mean you send it to the city's privacy officer for review?
Correct, that's correct. The FOI office, yes.
And did risk management have any role in consulting on FOI requests that didn't involve the risk management's records, but rather some other user department's records?
Not that I recall. It may have happened that we got a call from someone in a department saying, I've got this FOI, I want to run it by risk. But my response, and I'm sure that call would have come to me, would have been, you've got to provide what has been asked for. If you really want to discuss FOI or MFIPA, put in a call to legal services.
Okay, so here Ms. McNeil from Legal Services is saying she wanted to talk to you about this. Was that unusual as it relates to FOI requests?
I would say no one in legal had ever come to me before to discuss an FOI request. That's a fair assessment.
You said you recall speaking to Ms. McNeil. What was the focus of that first discussion that you had with her? I think she explained to me what the request was and what the, early stages at this point. I think she would have explained what report or reports are likely to be responsive. And I don't recall specifically, but I'm guessing she would have inquired as to files or claims that we had for the Red Hill or possibly the Link, which in my less than basic understanding of privilege might lend itself to a different analysis of what is responsive and what isn't. So I would have imagined that's why she was coming to me to discuss. And I would have said, yeah, we've got these files. I think at the time it was 4. Okay. I'm not sure I entirely followed your last answer.
Okay.
Maybe I'll rephrase my question and we can go from there. Why was Ms. McNeil raising the Tradewind report with you from your perspective?
From my perspective, I can't speak for her, obviously. From my perspective, I would say that she wanted to know if there were claims related that might be related, or if this report might be related to the claims that we already had.
Okay. What was she asking you about whether this report had been produced in any other litigation?
I don't think she did.
Into that level
I don't recall, but I don't think she did ask me that.
Okay. And what discussions, if any, did you have about the potential impact of a disclosure through the FOI process on the Red Hill related litigation?
During that initial discussion?
Yeah.
Okay. Well, I was pretty frank in my opinion. Not my opinion was that knowing, whatever the narrative at that early stage was about the Tradewind report, I would have been concerned that release of this report would have an adverse impact on our ability to defend claims. That being said, it was way outside of my purvey to decide what is responsive and what isn't. But for the sake of defending, my hope was that they weren't responsive.
Did Ms. McNeil convey to you if she had a preliminary view about whether the Tradewind report was in fact responsive to the FOI?
I don't recall her specifically saying one way or the other.
Okay, and this may be jumping forward a bit in time, but at some point, did Ms. McNeil convey to you her view about whether the Tradewind report was responsive to the FOI?
Yes, I do remember, the narrative turning to these, the Tradewind report is responsive.
And despite your hope that it was not responsive,
can I rephrase that? It wasn't, it's not that, hope is maybe the wrong word. Just in terms of ability to defend, I saw this as something that would be a hurdle to overcome in the defense.
Thank you. I think I understand the rationale for your rephrasing. Given that view that you held about the hurdle that this would create, did you accept Ms. McNeil's opinion that the Tradewind report was responsive when she conveyed it to you?
Absolutely. That being said, I wanted to be sure that we had done all due diligence in making that decision, because my primary concern was putting our insurance coverage in jeopardy.
And did you and Ms. McNeil have discussions about that due diligence at this first meeting on or about November 13th?
I can't say for sure. Certainly it was discussed at some point.
Okay, we'll come to it. What about your primary concern about putting insurance coverage in jeopardy? Was that discussed with Ms. McNeil at this first meeting?
I again can't say for sure. I doubt that it was.
Okay.
That was probably roaming around in my mind, but I don't know that I brought it up at that first meeting.
Okay. Registrar, you can close this down. And if you can go to 156, please. Can you call it 157 as well, please? So if you look at paragraph 375, this is about a week after the discussion with Ms. McNeil. So November 20th, Ms. Audie emailed Mr. Sabot and you with the subject line PW Red Hill matter. And I'm actually going to bring up
paragraph 375.
Sorry, 371.
Okay, got
at the
it.
very bottom of 156.
Got
But
it.
I'm actually I'm gonna bring up the underlying document just because I think it's a bit easier to read.
Sure.
And that is HAM 62477. Thank you. And if you could call out the body of that email, please. Thank you. So this is from Ms. Audie. Did you work regularly with Ms. Audie?
Well, I would say my regular liaison, if you will, or my regular communications were with Mr. Sabot, but certainly I wouldn't say it was unusual for me to communicate with Ms. Audie, particularly on issues of higher importance.
Okay. So this email says, further to our discussion last week, do we have any concerns with Dan McKinnon speaking to Gary Moore on the issue of the report regarding the friction to get more of his perspective and determine if there are other documents we need to be aware of? So just stopping there, Ms. Audie starts off by saying, further to discussions last week, do you recall having discussions with Ms. Audie and Mr. Sabot in the week before November 20?
I do not.
And sitting here today, is that to say that you have confidence that you did not have discussions, or that you just
no? I'm imagining I did. I'm saying I don't remember them. I don't remember them as formal discussions, i.e., a meeting being called and taking place.
Okay. The next paragraph says, where are we with regards to speaking to David Bogosian? And out, I think that's supposed to be our assessment of the risk/impact on litigation matters and the need for an interim ? Should we set up a meeting to review with Berdina the MPIPA issue? Does that refresh your memory that the many things that are referenced in that those two sentences about meeting with Mr. Sabot and Ms. Audie in the week before?
I do remember conversations, and it would have been on 4th floor at 50 Main Street, where we discussed acquiring some form of opinion from an expert who turned out to be Mr. Bogosian, who I had no objection to them retaining him. Not that I would have had a whole lot of say in the matter, but I certainly was well aware of David and his abilities, and was quite happy that they were turning to him. I would have had little, if any, input on the assignment to him in terms of what was expected from him.
Okay, just stopping there, you said you recall discussions about acquiring some form of opinion from an expert. So expert can mean lots of things.
Yeah, sorry.
Was it particularly from a lawyer?
Yes. By that I meant, David, a very well respected insurance defense counsel, particularly in the area of municipal defense, and probably with even boiling that down further into defense of roads related claims. David certainly had worked, had represented the city on some of our files, and he was, what I liked about it was that whatever opinion he provided, the insurers would be comfortable with it. They were well aware of David's abilities, and certainly would put a lot of faith into his opinion.
Okay. So you said you had no objection to Ms. Audie and Mr. Sabot retaining Mr. Bogosian. Were you in favor of the idea of obtaining some sort of report from a lawyer with expertise like Mr. Bogosian had?
Yes, definitely.
For what purpose exactly?
For exactly for the purpose of establishing with the insurer that we were exercising all due diligence in handling this matter. Like I said, this is, and I think I said this earlier. It's unusual in that normally you report to the insurer when you have a claim. In this particular instance, we would eventually be reporting to the insurer of a situation that may lead to claims. So I was pleased that we would have a document from a highly respected defense lawyer sort of summarizing everything that had happened to date and providing his opinion.
What was your expectation about what he would be providing in his opinion? Not his conclusions, but
right.
His opinion on what topic?
For my concerns, sitting from the risk management, from manager of risk management, I was expecting or was looking forward to or interested to see his opinion on how the release of this information would impact litigation that is currently in progress, possibly litigation that was closed in the past or litigation that was never started in the past, and how it would possibly attract future litigation. I also had an expectation that he would comment on the responsiveness of the information to the FOI request. That was an area of particular concern to me as it relates to the relationship with the insurer. My biggest fear was that we would provide the Tradewind report or other reports to the FOI office. They would get released, and then the insurer would have a look and say, well, this is clearly not something that needed to be responsive, and now you've prejudiced our position in our ability to defend the claim on your behalf. So we will be doing so under a reservation of rights, or they will simply just deny coverage. So that's a nightmare for a risk manager. So I was sorry to be so long-winded, but those were my primary concerns and expectations of Mr. Bogosian's opinion.
Thank you. That was quite helpful and not long-winded.
Thank you.
On the last point, the issue of coverage and the responsiveness, can you explain in somewhat more detail why you were concerned that an insurer might deny coverage based on an FOI, and how you were hoping that Mr. Bogosian might navigate that issue for you?
Sure. As the insured, you are expected to support yourself in accordance with the insurance contract. And, it's not something that I can recite to you verbatim, but you obviously are expected to conduct yourselves so as not to put the insurer's ability to defend in jeopardy. And, it has come up in the past, and this was another sort of offshoot that I was happy that Mr. Bogosian was going to be involved. It had come up in the past where senior staffers or counselors in particular had made public comments, that were adverse to the interests of the defense of the city. And quite often situations like that would lead to the insurer, threat. It had never come to a situation where coverage was denied, but certainly where they were unhappy with our performance, they may have sent a reservation of rights letter or sort of threatened the fact that you are putting your coverage in jeopardy. And again, that is, that's a road that you don't want to go down as the main conduit between insurer and city.
Okay. So you were hoping that Mr. Bogosian would provide a second opinion about the responsiveness, and that regardless of what his opinion would be, you could then take that to the insurer for a little bit of extra weight.
They would be much more comfortable. I think they had relative confidence in the ability of the city's legal services, but certainly the addition of Mr. Bogosian's opinion, which I think matched that of Ms. McNeil's, would sort of make our decision unassailable, I think.
Okay, thank you. Just going back to the other expectation that you had for Mr. Bogosian to deal with or to opine on the impact of the release of the Tradewin report on litigation, past litigation or litigation that had never been started. So just those two terms, you mean for past litigation, you mean litigation that had been resolved?
Not necessarily resolved by us. Certainly there may have been situations where two vehicles may have collided on the Red Hill and litigation had resulted from that in the absence of including the city. Now, when, if this information appears on the front page of the Spectator, an enterprising lawyer might say, well, had I known this at the time of this litigation, I would have included the municipality, which is a very serious consideration in light of the presence of joint and several liability.
And for litigation that had never been started, was your concern that an enterprising lawyer or just a member of the public would see the release of the Tradewin report and discover that they in fact had a claim that they had not previously thought that they had?
Correct. Yeah, discover being the key word. Claims that I don't think I need to explain it to you, but claims that otherwise would have been statute barred might now be available because the limitation period has been moved forward by discoverability, if I can apply my layman's lawyer terms.
Sure. So did you expect Mr. Bogosian to go into the particular claims that were currently before, that were currently on risk management's list of claims in particular, and do specific assessments about those claims?
No, I didn't have that expectation.
And in terms of Mr. Bogosian commenting on any measures that would be appropriate between November of 2018 and when the repaving was going to happen on the Red Hill, would that be of interest to you?
Yes, certainly of interest, yes.
And again, that's a matter of managing liability, but prospectively rather than retrospectively?
Yes, you could say that, yes.
Do you recall having discussions with Ms. Audie or Mr. Sabot about whether or not to ask Mr. Bogosian for an opinion about interim measures that could be taken until the repaving was done?
I don't have specific recollection of that.
Do you recall any discussion with Ms. Audie and Mr. Sabot about making an interim report to council?
No, I don't have recollection of that, and nor would I have been really expecting to be consulted on something like that.
I'm not asking about your consultation. I'm just asking about your involvement and your recollection.
Oh, well, just leave it to the first half of my answer. Then I do not recall a discussion of an interim report.
Okay. In terms of unrelated to Mr. Bogosian particularly, do you recall any discussions again in November of 2018 with Ms. Audie and Mr. Sabot about getting a assessment of safety measures from a non-lawyer expert, from a friction expert or a safety expert?
No, I don't recall that.
Back in 2013, when you said that lawyers love the word, ought to know, or you ought to have done something, were you thinking at this time in November 2018 about how to position the city for future litigation through getting experts?
Oh, I'm sure I would have been thinking about it. At this point in November of 2018, I was well aware of the fact that I had nominal understanding of all the various information that was out there. So, in my mind, I'm thinking, first order of business is to get your head around everything that's out there, which, I'm not so sure ever happened, certainly previous to the time it went in front of council.
And when you say that, you don't believe that you had your head fully around all these issues before February 6, 2019?
Correct. I didn't know who SEMA was in November of 2018. So there was an awful lot of information pouring in, never mind SEMA, but SEMA reports of certain dates and, what information was in those reports. So it was, it was a whirlwind of information that you're trying to process.
Did you anticipate that the city would require some expertise to better understand what the conclusions in the trade report meant?
Sorry, could you ask that again?
Sure. Did you anticipate in November 2018 that the city would require some expertise to better understand what the conclusions in the trade report meant?
No, I don't think so. I think it would have been incumbent on Mr. Moore or staff or his staff to report to council at some point just what information was in the trade wind report and possibly various other reports, and what their interpretation of those reports was, and how they what their action items were coming out of receiving those reports. I didn't think at the time that it would require outside expertise.
Maybe I'll put my question differently. Did you anticipate that the city was going to require some expert in litigation to respond to the conclusions in the trade wind report about the level of friction on the Red Hill?
You talking about Mr. Bogosian?
No, a non-lawyer expert, a safety expert or a friction expert.
No, I'm going to give a very similar answer, I think, to what I just gave is, while an outside expert may have been required, I would have thought that step would have been taken after a report submitted by the city's own engineers.
Okay, and do you remember through November or December 2018, meeting with the city's own engineers or public works, traffic safety staff, during which you better understood the trade wind report and what its conclusions actually meant?
I wouldn't say at any time that I felt I had a fulsome understanding of the report. I recall one meeting in particular that took place at Legal Services, where I believe certainly Dan McKinnon was there, and who Mr. McKinnon, GM of Public Works, and Gordon McGuire was present. Nicole Audi was present. I'm not sure if Ms. Swaby was present, and I'm not sure if Mr. Zagaric was present, but at that meeting, I got the most understanding of the various information that was being considered. Everything from SMA to friction testing to SEMA reports, when and where they happen and what was contained in them.
Okay, we'll try to nail down a time frame for that meeting as we go through.
Sure.
When you say you got the most information at that meeting, in November and December, I know you attended quite a few meetings. Did you have an impression that the public works staff were taking steps to assess the safety of the Red Hill during this period of time?
Oh, yes, I think so.
In what ways were they doing that?
Well, I can't say specifically, but in my mind, I would have imagined that they were probably going through everything that they had received from consultants and, reviewing their decisions in terms of responding to the reports that they had received over the course of time.
Okay, so going back and reviewing what they'd received, do you recall being left with the impression that public works staff were taking concrete steps to test the roadway, assess the roadway, anything concrete to ensure that the roadway was safe?
Moving forward or looking back in retrospect? Moving
forward. Or
moving
frankly,
forward
at the present, just in that moment in December of 2018.
Okay, so we're at this point in time. What can we do moving forward to enhance if necessary? Is that what you're asking?
No, I'm not asking about enhancement. I'm asking, were you left with the impression in November or December of 2018 that public works staff were taking steps to assess the current safety of the roadway?
Oh, yes, I had that impression. Yes.
And what concrete steps did you understand that public works staff were taking?
I would, again, I think it's a repeat of what I said was, they were, and again, I don't know for certain, but I would have thought that they would be looking at every recommendation and any report that was provided to them and making sure that they had acted appropriately and responsibly to recommendations that were made, certainly in keeping with budgetary constraints.
Okay, so I can see why that would be your assumption. Do you have a recollection of being left with that impression for some reason that that's what they were doing? Or were you just assuming that that's what they were doing?
I would say it was an assumption, but knowing, it was a very well-founded assumption, knowing the individuals involved.
Okay. We'll come back to plotting through some of these meetings that you attended to try to nail down that time and of course, your impressions during that period of time. I'm just going to jump back for a moment into November of 2018. Registrar, you can close this call out and close the document.
Thanks. It's weird to talk without seeing faces.
Can you not see the windows when the call it is up?
No, well, I moved them because I'm just on my laptop, so it's easier to view the document as a whole if the faces aren't up. So the document was up for a period of time there. I felt a little disconnected.
Next time you put a call up, maybe we'll switch your gallery view so that you can see both, if your laptop is big enough to do that. And I'll try to be mindful of taking down call outs when they're not necessary. Can you bring up a document, Registrar? 9A, page 155 to 156, please. Registrar, if you could call out 370, please. So you email Ms. Audie and Mr. Sabot under expressway claims. And you say, my review indicates that we have 4 significant claims that could be theoretically impacted by the FOI request. None of them cite friction factor as far as I can tell. And then you say, this is just my quick review in advance of Diana returning. Do you recall Ms. Swaby was on vacation during this period of time?
I don't recall why she was absent.
Okay.
But she obviously was absent.
Okay. So you said that you'd done a review that found these 4 significant claims. What was your process for that review?
Well, normally if Diana had been there, it would have been, what claims do we have for the Red Hill Valley? But in this instance, I would have, I don't recall doing it, but I'm certain I would have sought out Mr. Chamberlain and said, run me a report of Red Hill claims.
So when we're talking about claims in this email, are we talking about statements of claim, pieces of litigation, as compared to what that
yeah, I get what you're asking.
Before?
Yeah, well, as it turns out, I believe all of these were in litigation, but it is possible that there, had someone simply submitted a claim on their own, it would have showed up.
Okay, so you weren't intending to limit these to pieces of litigation?
That is correct.
Where it says none of them specifically cite a friction factor, what steps did you do to provide that information to Ms. Audie and Mr. Sabot?
I would have looked, I would have gone through the paper files and, looked at probably the statement of claim and any notice of claim if one came previous to a statement of claim, and looked for, a specific reference to lack of friction or slippery condition of the roadway being the proximate cause of the accident. I believe for all 4 of these, the statement of claim would have been a very long list of potential areas of negligence, really all relating to road design.
Okay. Registrar, can you close this call out? I'm going to call out another document, but first, why don't we try to sort out your screen just to see if you can see. If you go up to the gallery view, you may be able to change the view so that you can see our windows on one side and then the two documents.
Would that be side-by-side mode or?
I believe so, yeah.
Oh, that's better. Thanks.
Registrar, can you bring up 368 and 368 that traverses the two pages, please? I'm sorry, my instructions were completely unclear. Can you go back to page 155 and 156? And can you call out paragraph 368, which is on the bottom of 155 and to the top of 156? Sorry. Thank you, Registrar. So you forwarded Ms. McNeil's email in which she attached the Tradewin report to Ms. Swaby on November 20 and said, FYI, the preliminary thought is that this report will have to be released to the requestor. That preliminary thought, is that from your discussion with Ms. McNeil?
Yes.
Obviously not a good turn of events for any of our RHBE files. And then you'll see an email where I advised her the 4 files I could find. Please provide more information. So why did you provide the Tradewin report to Ms. Swaby on this day?
She was the file handler of these 4 files.
Before November 20th, had you spoken to Ms. Swaby about friction testing or the Tradewin report?
If she was present in the office, I'm presuming that I did. But I don't have a specific recollection.
Okay. Do you remember her giving you information that left with you with the impression that the Tradewin report was not a new document to her around this time, November 20th?
Not that I specifically recall, no.
Okay. So you say obviously not a good turn of events for any of our RHVE files. And where you say obviously not a good turn of events, do you mean, as you said before, that release of this document would not be favorable to a city's defense?
Yeah, and I don't mean for that to sound callous or uncaring. It has to do with simply a cold hard analysis of the city's ability to defend, and my sort of in conjunction with my opinion, which was largely formed by what I had heard about the report, that it was inconclusive and sort of had been established in our minds, myself and Diana's, as a bit of a red herring. But in my experience, I had seen trials turn on a lot less than something like the Tradewin report. So I had significant concerns about the impact of the Tradewin report on the analysis of liability.
Thank you. Registrar, you could close down the call outs. So just on that point, so we're in November 20. In fact, you can call out, you can close down the, actually, Matt, can you see me now? I need to close this down. Oh.
Yes, I can see you.
Good. All right, great. So I won't close it down. We'll come back to it. So you said we're November 20th, and you said that your opinion had been, was made in conjunction with what had largely formed in your mind about the Tradewin report being inconclusive. Can you pinpoint when you received information or the suggestion that the Tradewin report was inconclusive?
I can't pinpoint. I do know that I had informal discussions probably on a daily basis with, I would say predominantly with Mr. Sabot, about the report and, what it its contents were and what they meant. And then you take that and you go back retroactively, and I'm certain that we would have had a file of media reports related to accidents on the Red Hill. You look back and you find Gary's, Mr. Moore's quotes about back in as far as 2017, I think that article appeared that said, the findings were inconclusive. So, and having applied my own layman's lens to reading the Tradewin report, it wasn't something that I thought in a perfect world would cause us a lot of grief defending the claims. But again, as I said earlier, I had seen trials or arbitrations or mediations turn on things that were, a lot less impactful than the Tradewin report. So I was very seriously concerned about its presence.
Okay. So I'm going to suggest to you that there was a lot of discussion amongst city staff in November and December of 2018 about this. By November 20, you're about a week after Ms. McNeil has first provided you with a copy of the Tradewin report. Do you think that within that week you had already landed on the conclusion that the Tradewin report was inconclusive? Or was that something, and a red herring, or was that something that built over and over the period of November and December?
I would say, whenever I did my initial reading, I would have not thought a lot of the report as a defining document, lending itself one way or the other towards liability versus no liability. As discussions about the report carried on, I think that the general narrative was that it was more red herring than anything else.
Fair enough. And I think I probably said inconclusive and red herring in the same together.
I think red herring is somewhere in these productions. So
it is. In fact, just a few days later, I was really actually just trying to focus on inconclusive. Okay, we have just a few minutes before we're going to take our lunch break. I'm going to try to take us through a few more sets of emails before that. Registrar, can you go to 158, please? And if you can call it 375. So in this email exchange with Mr. Sabot, there's a reference to Bogosian not being involved in these claims, I presume as defense or as defense counsel. Was it, were you given the task of determining whether Mr. Bogosian was involved in any of the claims?
I don't recall specifically. It would have been an easy task,
yes.
Given that we had four, and I probably was already aware that Shillington's was on at least one of them. So, the paper files were there, very easily attained. So I would have found out that Shillington was on one or two, and in-house counsel was on the others.
Do you recall a particular rationale for preferring or being pleased that Bogosian was not involved in the claims?
It wouldn't have mattered to me if he was. I would have been happy with just about anyone that I shouldn't say that. My preference would have been the appointment of someone who I knew would be approved by our insurers. So Bogosian was one of them, so I was happy about that. Had he been involved in the defense of the claims and declared a conflict, I would have been equally as happy with, say, Learners or Thomas Gold Pettengill or Loops Dixon. Any of them, I would have been, more than happy to know that they were being consulted.
In this same email, you say, I think we should let the insurer chime in on this too. If they disagree with the city decision to release the report, it might adversely impact coverage. So I think we've already talked about your views on that. Do you recall having a discussion with Mr. Sabot, who is on this email, about when it would be appropriate to let the insurer chime in?
Not so much as when as, the fact that it was going to happen. What I don't like to do is put the insurer on notice without what I feel to be sufficient information. And particularly given this situation where we're not really talking about a specific claim, we're talking about an issue. So, it was kind of, I think at this point, I felt we had enough information to bring them in, so to speak.
Okay, so you didn't feel that you needed to wait to retain Mr. Bogosian and get him to do an opinion before putting the insurer on notice?
No, I would have been happy to let them know we were exercising due diligence by involving, again, Mr. Bogosian or any other of those firms had it been them.
Okay. Just stopping here for a moment, when you say we should let the insurer chime in, the city has more than one insurer. Is that right?
Yes. In this particular instance, let me test my memory. We were insured with the Frank Cowan Company up until 2011. And then we switched to JLT in 2011. So you're talking about two different managing general agents, if you will, but they essentially are the insurer. They act as the conduit for the various subscribers. So we always refer to them as the insurers. So
okay,
those are, two companies that would have needed to be notified.
Thank you. So you didn't feel the need to wait for Mr. Bogosian's opinion to contact the insurer?
No.
Was it your preference to contact the insurer or the insurers before anything was released, either through the FOI or in some other way, like through council?
Well,
we trying to give them a heads up before it was made.
Yeah, certainly my preference was to not have them find out about it through the media. And, I always want to, provide them with as much awareness as possible of a given claim situation, or again, this unusual situation where we had an issue that was going possibly lead to future claims or have an adverse impact on claims already in place.
But that's exactly what happened, isn't it? That they found out through the media?
No, I don't think so.
No? You provided them with notice in advance?
I believe so, yes.
Okay. Did you do that by
email? Are you getting to that?
Mm-hmm.
Okay.
We'll get to that. I see a number of back and forth with the insurers in February.
Okay.
What do you recall about when you provided notice to the insurers?
In my recollection, they were put on notice either formally or informally previous to us going to council.
Okay. I see it as exactly 1 o'clock, and I'm going to move on to a different topic. I think this might be an appropriate time for lunch.
Okay.
That sounds fine. Let's stand adjourned until 2:15.
Registrar, could you put council into a breakout room, please? Commissioner, may I proceed?
Please do.
Thank you. Before the break, we were talking about interactions you had with Mr. Sabot in late November. We're going to go back to that time period now. Registrar, can you bring up OD 9A, page 158 and 159, please? Thank you. So you'll see at the bottom of 158, paragraph 376, Ms. Swaby replied to your email from November 20th, where you'd asked her to look at, you'd said you'd found those 4 claims, but asked her to inquire further. Registrar, can you pull out the top of 159, please? So she says this report concerns the Red Hill and the Link. As far as I can tell, it's a red herring. Most accidents happen due to driver error, speed, tire blowing, dangerous driving. All of our serious files are for the most part being defended by Shillingtons, save and except Shirk O'Hare, which is Donna Lizzo. And that's a internal city lawyer, is that right?
Yes, yes.
And one being handled right now by Dan Bartley, Kanajar to Renjnian. And that's also an internal lawyer?
Yes.
Okay. Shillington's recently asked about the report, citing that it will have to be produced in the city's affidavit documents in at least one of the claims. An inquiry did come from Shillington's office concerning this report. The inquiry referred to Gary Moore, who indicated the report was not presented to council. So just stopping there, this email does not, in my reading, make clear that Ms. Swaby has a copy of the Tradewin report. It just makes reference to Shillington's asking about the report. What did you understand in November, end of November, November 23, about whether Ms. Swaby had a copy of the Tradewin report?
Oh, I would have been, I would have known that she had seen a copy of it, and my reading of this email would indicate that to me.
Okay. So that's how you would read this email. Shillington's recently asked about the report, citing that it will have to be produced. You'd read, you read that.
Sorry, what's the date of this, Emily?
It is November 23.
Yeah, and I can't fathom that when I came into possession of the report, I wouldn't have immediately provided it to her.
So you did on November 20th when she was away from the office.
Okay.
And you asked her to, you said, I found these 4 claims, but can you dig into them when you get back?
Uh-huh.
And her response is, this report concerns the Red Hill and the Link. And then she references Shillington's recently asking about the report, citing it will have to be produced. And then she says an inquiry did come from Shillington's office concerning this report. So as I read these things together, she is not expressly saying to you, oh, I already had a copy of this report from Shillington's.
No, she's not saying that.
So I'm trying to understand, as I read this, Ms. Swaby is providing you with this information in a way that is new information to you. But she's not saying that she has a copy of the report. So I'm trying to understand if there was any discussion or how you understand when Ms. Swaby told you that she already had a copy.
I really couldn't say. I certainly would have provided her with a report, and I think we established that I did.
Yeah.
It appears to me that I think we can establish that she has read the report, but you cannot tell from anything in this email if she had the report previous to my providing the report to her. She may have known about it, I suppose, but don't know that she's read it. No.
Okay, so I can tell you the inquiry has documents to establish that she did have a copy of the report. And months later, she actually flips you the email where she received the report in May of 2018.
Okay.
But at this period of time, can you recall either way whether you were aware on November 23rd that Ms. Swaby had already had a copy of the report?
No.
Okay. I will come to the moment in time where she flips you the email from Shillington's copying with a copy of the report, and maybe we can come back to this issue of when you first understood that Ms. Swaby already had a copy when we get there. In her last paragraph, she says, if there's a specific question I need to ask Shillington's, please advise. Was there a specific, sorry, just because we had the lunch break, just to remind you, you had said in the email where you gave her the report, Diana, please contact Terry Shillington as soon as possible.
Uh-huh.
So I think that's part of her response is, if there's a specific question I need to ask Shillington's, please advise. Was there a specific question that you wanted Ms. Swaby to raise with Shillington's?
I don't believe so. If there's not a response to this email, I would suggest that I didn't give her a specific one. My interest would have been for their general all-encompassing impression of how this affects the litigation.
Okay. Registrar, can you close this call out and bring up 59 and 60? So on that same day, you'll see in paragraph 377, Ms. Swaby did email Mr. Shillington, marking it with high importance, and says, hi, Terry, this afternoon I'm meeting with the GM of Public Works, as well as the Director of Legal Services and John McClellan of our office concerning an FOI request to release this report. I take it that they do not want to release the report. Do you have a moment to discuss the implications of the release and how the report affects the litigation we have ongoing? So were those 2 points, one, discuss the implications of the release, and two, how the report affects litigation? Is that the nature of the questions that you were hoping Ms. Swaby would ask? Certainly
in a general sense, yes.
Okay. She says, I take it that they do not want to release this report. Had you conveyed to Ms. Swaby that you or the GM of Public Works or the Director of Legal Services didn't want to release the report?
And I think I've spoken to this issue previously, so I don't agree with her phraseology there. It's not a matter of want; it's a matter of are we sure it needs to be released? Does it qualify as something that is responsive? So I would think I would be looking for Diana to receive an opinion from Shillington saying, if they feel qualified to reply about an FOI request, what their opinion was on that.
Okay. So you thought, at this point, did you know that or were you hopeful that Mr. Bogosian was going to address that issue, but you also wanted Shillington's to address that issue?
Sure, why not?
Okay. And in terms of leaving aside the release under the FOI or not, were you also hoping to get more insight into whether the report needed to be included in their affidavit of documents in this litigation?
It would have been of interest to me. I mean, again, I was always somewhat confounded by what constitutes privileged documents and what constitutes something that needs to be included in Schedule A, Schedule B. If Shillington's was of the opinion that it needed to be included in their affidavit of documents relative to that piece of litigation, then that would be good enough for me. I'm certainly far from an expert on that topic.
And is that true even if, or regardless of the decision made to release the the Tradewin report as part of the FOI? Did you view those as two separate?
That would be a very weird circumstance, wouldn't it? Sorry to answer a question with a question, but I can't foresee that happening. I don't know how to answer that.
I think I will take your question and try to rephrase it into a question of my own. Were you looking to Shillington's to advise you about whether they thought the report needed to be included in the city's affidavit of documents if the Tradewin report was not responsive to the FOI request?
Oh, I see. Sorry, I don't know that I heard that correctly. I was again. This is through Diana. I was interested to hear Shillington's opinion on both aspects.
Okay.
So if it qualified for one, if it qualified for the other, if it qualified for both or neither, that's, to my mind, that's why that's why you have lawyers and that's why you consult them. So I was an open book as far as the topic goes.
So you'll see at paragraph 380 on page 160 that Mr. Thompson replied internally with his colleagues and said, I can't think of any concern in our litigation except that it is not relevant. The last I heard, the report had never been produced to council. If they decide not to provide it under the FOI request, they should at least let us know so we don't include it in our productions. Did Ms. And then Mr. Shillington said, thanks, she's good with our review and we'll let the others know. Did Ms. Swaby report back to you that Shillington's believed the Tradewin report to not be relevant to the litigation that they were handling?
Not that I recall.
Did she report back to you that Shillington's would be amenable to removing it from their affidavit of documents, the city's affidavit documents, if instructed to do so by the city?
Not that I recall.
Okay. And when you say not that you recall, do you remember Ms. Swaby conveying anything back to you from Shillington's, or you just can't recall either way?
I can't recall either way. I'm sorry.
That's all right. Do you recall having a meeting with the GM of Public Works, who at that point would have been Mr. McKinnon, Ms. Swaby, because she says she's going to attend, and then someone who is listed as the Director of Legal Services?
Yeah, that was a term commonly used to designate the city solicitor. People tended to understand that term better than saying city solicitor because the heads of departments were all directors. So it tended to get referred to that way. It would have been Nicole.
Okay.
Yeah.
So do you remember having a meeting with Ms. Swaby, Mr. McKinnon, and Ms. Audie?
My only recollection of a formal meeting was the one I described earlier. And certainly Mr. McKinnon was there, and certainly Ms. Audie was there. It was at Legal Services. Diana was there.
Mm-hmm.
I don't recall specifically Diana being there. And to my recollection, Mr. McGuire was there as well.
Okay. What about Mr.
That's
Zagarek?
my only specific recollection of a formal meeting.
Okay. What about Mr. Zagarek?
May or may not have been there.
Okay.
I cannot say definitively.
Okay. Do you, I think you spoke a little bit about this, the recollection of this meeting that you had, and we were going to try to pinpoint the time.
Uh-huh.
When you say you only have one definitive meeting that you can recall, is that to say that you have a specific recollection of one meeting, but you also attended a number of other meetings, they just all kind of run together?
Well, the interesting thing to me is is specific recall of a meeting at legal services, of a formal meeting with a start time and and you responded that you would attend. I would think there's another meeting that's been referred to that occurred at City Hall, and it was relatively unusual for me to go over to City Hall for a meeting. I would think I would remember that, and I certainly would remember a meeting where the mayor was involved, and I do not recall being in a meeting with the mayor. So this is my, absolutely did I have a number of informal conversations and meetings, if you will, on the subject, but this is the only formal meeting I recall.
Okay, and so when you say formal meeting, do you mean like a meeting with an agenda, or do you just mean that someone sent you an appointment for a specific?
I would say an appointment. I don't recall an agenda, probably because the agenda was one item, right? Let's talk about the Red Hill and the trade wind and the FOI request.
Okay, why don't we go? Maybe this might assist. Can you, Registrar? Can you go to page 156, please? And can you pull out 369? So this is an email from a legal assistant with a calendar invitation to Ms. Audie, Mr. Chabot, you, Mr. McKinnon, and a recipient that I think is the booking the boardroom, City Hall, first floor, 171, seats 8. And it's next steps on RVH, and it's scheduled for November 26th. Is that the meeting that you think that you are remembering?
No, this is the one that I would think that I would remember because it was at City Hall. So it involved walking over there and finding room 171, which the numbers are crazy at City Hall. So it was never a sure thing. No, the meeting I specifically recall happened at Legal Services, 50 Main Street East.
Okay. I think
I'm not saying I wasn't there, Emily, but I do not have a specific recollection.
Okay. All right, let's close this down. Registrar, can you go to page 407 and 408? And can you call out a 933? So the inquiries received evidence about these undated handwritten notes authored by Mr. Chabot, and they're only partially excerpted below. Mr. Chabot's handwriting is quite hard to read, but we can go into the handwritten notes if you'd like. And there's a reference to you. It says, John, RHP, what are we telling him outside? I think it's operation. And then there's a reference to risk, DS 1 or 2, Donna 2, Dan 2, Dana has SEMA reports. And Mr. Chabot seems to have some not conclusive recollection that these notes refer to a meeting that happened in late November or early December, and that he understood that he was getting information about the number of RHV litigation cases that DS, being Diana, Donna, and Dan, had.
Makes sense.
Does that help you with whether with a meeting that Mr. Chabot was at sometime in late November, maybe November 26th?
It doesn't help. Again, those are possibly, I mean, the numbers beside DS and Donna and Dan make sense, I think. But again, my recollection of the one formal meeting is one that occurred at Legal Services, and these notes could be from that. I don't know.
Okay, I'm going to try out one more way to
Sorry.
attempt to nail it down. Our registrar, you can close these down, and if you can go to paragraph 600, page 253. And if you can call out paragraph 600, please. Sorry, 600 rather than 601. So there's a calendar invitation for December 14th to Donna Lazo, Mr. Bartley, you and Ms. Audie. I may have to go in and maybe Mr. Sabo, another version indicates that. We can go in and see where it was, but I think this one is at Legal Services.
Okay.
Does that assist you, just these attendees? Do you think that is the meeting that you have a specific recollection about?
It doesn't jive with my memory because this looks like it would have been a meeting given the invitees to discuss the claims that are already open. The distinct memory I have of a meeting definitely involved Dan McKinnon, and Dan wouldn't have been involved at a meeting to only discuss the claims. So it's certainly possible we had a meeting to discuss the current status of the Red Hill Valley claims. I don't have a specific recollection of it.
Okay. In respect of this meeting, December 14th, you're quite correct. It is really just you and those from Legal Services. Do you recall whether Donna Lazo and Mr. Bartley received copies of the tradesman's report before this meeting or at this meeting?
I couldn't say. I really couldn't say.
All right, we can close this down. Registrar, could you go to page 160, please? And if you can call out 382. So this is the same day as the meeting appointment that we just looked at with Mr. McKinnon and others, and Ms. Swaby. And this may or may not help you refresh your memory, but on that same day, you emailed nwsa.ca@gmail.com, who I think we will learn is Ryan Ellis from National Walkway Safety Auditing. Is that right?
Correct.
Do you remember anything about that meeting with Mr. McKinnon that connects you in time to deciding to reach out to Mr. Ellis?
No.
Okay.
No. This would have been something of my own doing.
Okay. Who is Mr. Ellis?
Mr. Ellis is an acquaintance who I came to know through basically after work meetings, sort of drinks after work. He was acquainted generally with folks in facilities maintenance, and I believe he had contracts with the city for floor treatments. So he was, I don't know that you would call him or qualify him as an expert in terms of floor safety or surface safety, but the topic was of interest to me, and I had several conversations with him over time about floor treatments, and he would describe to me a machine that he used to measure, and I always get this term wrong, coefficient of friction, I think it is. And the readouts of this machine that he had would tell you, I guess, whether the friction factor on a given surface was sufficient. So it was interesting to me primarily because we would have slips and falls in our buildings, in change rooms at the pools, and in lobbies. Usually, if there was water on some of the marble surfaces, that kind of thing. So he came to mind as I was reading and struggling with the trade wind report, with a lot of the terms. And I thought, well, here's a guy I could probably reach out to who could provide, maybe to me some more understandable terms to allow me to understand the trade wind report. And it was also a bit of a test case in that I sort of wanted to see what he was capable of, because he had frequently suggested that we come up with a formal program of analyzing every building at the city, and coming up with a formal friction inspection review to establish, I guess, due diligence, if you guess, in terms of treatment of our walking surfaces and how safe they were for the public who is entering the buildings. So it kind of had the assignment had a bit of a twofold function for me.
Registrar, you can close this call out. The body of the email is as we discussed. Did you have a conversation with Mr. Ellis before you sent the trade wind report?
Oh, yes.
And did you talk to anybody at the city about your intention to contact Mr. Ellis before you did so?
If I don't believe I did. If anyone, it would have been probably Diana, but I can't say for sure that I did or didn't.
Okay. You later received Mr. Ellis's written report on December 12th. And we're going to go to that. First, let's go to the OD 240, page 243, please. And if you can bring up 244 as well. We have some excerpts from the report here. It's a 5-page report. I'm happy to go into it if you haven't reviewed it recently. Would you prefer me to? Okay. So we have the attached report. It has the introductory paragraphs at the bottom of 243. And it says quite clearly that NWSA does not claim to have an expertise in or complete friction testing on roadways. We do believe a third-party governing standard should be followed by anyone completing a friction testing program. So they put quite a caveat on what they say. And then Mr. Ellis says, after reading the report, a few questions come to mind about the type of friction testing program this is, and the three components of our friction testing programs: what organization is governed, how is it certified, and what are the testing methods and standards? And finally, is the equipment calibrated? And the remaining 5 pages go through those questions, and then conclude that there really is the program for testing is not regulated or required, and that testers are not certified, and that they don't have any sense of the calibration. Is that generally in keeping with your recollection of this report?
Yes.
You say, thanks, Ryan, good stuff. I'll make a few edits, but this is a helpful report. Why did you say you were going to make a few edits?
I never did. I don't, without having it in front of me, I recall a number of spelling and grammar errors that would need to be addressed if the report was going to be taken any further. I would say generally that I was disappointed with the report in as much that it didn't, again, given that my assignment to Mr. Ellis was twofold, it didn't really assist me in understanding the Tradewin report any better than I did. It certainly it didn't strike me as a very professional report, and it didn't give me a great sense for moving forward either, in terms of working with Mr. Ellis to develop floor safety program at the city. So I was to put it briefly, not particularly impressed with the report.
Okay. Did you provide a copy of the report to anybody at the city?
No.
And did it, recognizing you weren't particularly impressed with it, did it meet any of your objectives to help you be more conversant, or have a better sense of the terminology?
No, I would say not. I mean, the point of interest that I gleaned from it was about the recalibration, but I remember thinking at the time, it would be highly unlikely that an expert in the field who has been subcontracted by engineering experts, that being Golder, would not be using their equipment in the most appropriate way possible. So, I understood that maybe it's a possibility that they didn't, their methodology wasn't perfect, but I found it highly unlikely.
I'm going to move on. Registrar, can you go to page 195, please? And could you pull out 443, please? So this is December 4th, and Ms. Audie emailed Mr. Zagaric and Mr. McKinnon and said, I propose we need to get everyone together to discuss the totality of reports and information and review options. I propose Thursday afternoon. I would want you, and there's a reference to Gore, which I think is Mr. McGuire, Verdina and Ms. McNeil, and Ms. Audie, plus anyone who you think should be there. And Mr. Zagaric says, yes, do that. And that meeting is scheduled for December 6th. So I'm trying again in terms of having a sense of your meetings. So you remember one where Mr. McKinnon was there, and you independently recall attending a meeting where Mr. Zagaric was there.
Well, I think this is the one that I specifically remember attending.
Okay.
And I don't specifically remember Mr. Zagaric being there, but that doesn't mean that he wasn't.
Okay. Did you often interact or attend meetings where Mr. Zagaric was present?
No, not very often.
Okay. What do you recall? I'm going to close the call it. Thank you. We don't have any notes of that meeting to refresh your memory, so I'm just going to ask you some questions. Starting with, what do you recall about the topics raised and discussed at that meeting?
My most definitive memory is a discussion about the current safety level of the Red Hill Valley Parkway, and the question of whether it should be closed or not. And I was very interested to hear the thoughts of Mr. McKinnon and Mr. McGuire on that subject. And I was happy, both from a risk management standpoint and from simply just a citizen standpoint, that it was, they felt under no circumstances that it needed to be closed. That's my most compelling memory of that meeting. And it was the first time it was the first time I had the opportunity to meet or speak with Mr. McGuire. I remember thinking. This is the first time I've heard anything come out of his mouth about this particular situation.
So what do you recall was the context for the thoughts from Mr. McKinnon, Mr. McGuire about whether the road was safe? Was that part of a broader discussion that was occurring with the attendees?
Yes, it was definitely part of a broader discussion. And again, I remember sort of being not shocked, but surprised that closing the roadway was even something that was up for consideration. And again, I was, imagining or knowing that they knew a lot more about the situation than I did. I was sort of relieved to hear that, no, geez, we don't need to close the roadway. So, and there was a broader discussion of moving forward. Do we need to, is there anything we need to do moving forward with the roadway to make it safer, for lack of a better term?
And what came out of that discussion? Is there anything we need to do to make the roadway safer?
Well, specifically, I can't recall, except that I believe it was at this meeting where I discovered, or where I learned, that they were going to repave basically as soon as possible, and that sort of rendered a number of concerns about friction moot.
Do you recall whether Mr. McKinnon or Mr. McGuire explained why they thought the road didn't need to be closed?
Yes. I think, one primary concern was the chaos that it would cause. And, although it would, in theory, keep people off, what if they did take that step, if they felt it was necessary to do it, there would be chaos in the neighborhoods. You might be creating, I think, an unsafe situation in other parts of the city. But, I think the bottom line was that they didn't consider it to be an unsafe roadway. That was the primary reason why it did not require closing.
I understand that they didn't think it needed to be closed because they thought it was safe. Did they explain why they thought it was safe, such that it didn't need to be closed?
I don't remember specific commentary and reasoning behind that. Certainly that was an opinion of mine as well. And I don't know how much I would have chimed in that regard. Given that I'm not an engineer or a public works expert like I would consider Dan and Gord to be. Certainly my impression of the Red Hill, and it's unique because, again, I've traveled it literally hundreds of times, and as have family, as have friends, and I know what the traffic counts are. And all things considered, I think it at the time I thought, and I still do think, that it was a safe roadway.
Thank you, Registrar. Can we go to page 208, please? In the bottom of the page, 490, Ms. Audie emailed you and Ms. McNeil the day after that meeting that you were scheduled to go to. Registrar, can you go to the next page as well? And Ms. Audie wrote, I'm in the office today. Let me know if you're available to follow up on yesterday's discussion and the meeting was arranged for 9:30 the same day. Do you recall meeting with Ms. McNeil and Ms. Audie?
No,
Do you recall at that meeting on that December 6th that there was any discussion about the retainer of Mr. Bogosian?
not specifically at that meeting, no.
But you don't have a specific memory, or no, it wasn't discussed at that meeting?
I don't have a specific memory.
Okay. What about discussions about contacting road or safety consultant experts rather than legal experts?
I don't have a specific recollection.
Okay. Do you remember having any action items for you coming out of the December 6th meeting that Ms. Audie would want to follow up with the next day?
No, I don't.
Okay.
I think I at that point had provided, what they were expecting of me, and generally that meant claims information.
Okay. Were you involved at all in the retainer of Mr. Bogosian? Up past this
What do you
point?
mean? Sorry. Like I knew he was going to be retained, and I had no objection to it. My advice was not sought, shall I say. I was just sort of kept in the loop.
Okay. Registrar, can you go to page 249, please? And could you call out 588? So Mr. Sabot and Ms. Audie are going back and forth in respect of the December 13th, 2018 draft opinion that Mr. Bogosian provides to them. And Mr. Sabot says, I know John would like David to help with the approach to giving notice to the city's current and former insurers on this one. Had you requested that be part of the scope of Mr. Bogosian's opinion?
No, and I've seen this excerpt, and I'm not quite sure what Mr. Sabot was meaning by saying that. I think probably what I said was it would be helpful to have David's opinion in any notice provided to the insurers. I certainly didn't need help in providing notice to the insurers. I mean,
Okay.
whatever was going to be in Mr. Bogosian's report, that's what I would eventually provide to the insurers.
Were you looking for advice not about whether to provide notice or not, but the content of, say, how much information to provide?
To provide to the insurers?
Yeah.
No, I would never, it's not something you would look to govern or limit. It's whatever you have, you're going to produce for them.
Okay. Registrar, you can close this call it, and can you go to page 227, paragraph 539, please? Oh, that's not super helpful to call it just that. Sorry. Can you call out the paragraph above as well, please? Thank you. So there's some back and forth, including with Ms. McNeil, about gathering information for the FOI response, that it would be gathered by the first week of January 2019. And Ms. McNeil forwarded that information to Ms. Audie, Mr. Sabot, and to you. Do you know why Ms. McNeil was keeping you copied on FOI related emails?
No, I never asked her, and she certainly didn't explain. I think she just, and again, I'm speaking for her. I think she considered risk management as a maybe a satellite participant who deserved to be kept in the loop.
Okay, but you had no to-dos, no action items related to the FOI or this email?
Not as far as I recall.
Okay, Registrar, you can close this down, and if you can go to page 221, please. And if you can call out the paragraph at 526, please. So I'm not calling out all of it, but this is, no, if you can call it the right to the bottom. Thank you, Registrar. I'm not gonna, it goes on to the next page, but I'm not gonna call it out unless you'd like me to. Ms. McNeil exchanged emails with Ms. Audie, Mr. Chabot, and with you. I don't think you actually chime in on this one, but there's some back and forth about an audit commenced by audit services, in particular, Mr. Pellegrini. Did you have any involvement in this audit process?
No, none at all.
Did you have any discussions with Ms. McNeil about keeping you in the loop on the audit process?
No, I did not.
Thank you. You can close this down, Registrar. I think you said earlier you have no recollection of attending a meeting with the mayor about the Red Hill. Is that right?
I don't recall it, and I would think that I would.
Okay. Registrar, can you go to page 287, please? And 288, please. At 287 at the bottom, at 668, Mr. Chabot forwarded you a email and containing the draft Bogosian opinion that's dated December 13, and he does that on January 8. And all the email, the subject line is just draft opinion, and there's no body of that email. Do you recall speaking to Mr. Chabot before he sent you this email?
No, I don't.
Is it unusual for Mr. Chabot to send an email that doesn't have any information in it?
So hang on. So it's titled what?
We can go into it. It's 62042. So
okay, so
this is the whole chain which we're going to stay on. So but you see at the bottom it's just his signature block.
And I presume there was an attachment?
The Bogosian opinion is attached.
Okay. I don't know. I can't say there, normally you would expect a little bit of preamble, but it's possible he may have passed me in the hallway and said, David's draft report is in, I'm going to flip it to you.
Okay. Do you remember seeing a copy of Mr. Bogosian's draft opinion in December, like before the holidays? I can say we have no electronic.
I couldn't tell you when I first laid eyes on it, no.
Okay. I can tell you we have no electronic document that would suggest that.
Okay.
Do you remember seeing a printed off copy?
No, I don't.
Okay. Is it likely that this is the first time that you received the Bogosian opinion on January 8th?
I would agree with that.
Okay. And you flip it to Ms. Swaby just a few minutes later and say, give it a read. Why did you want Ms. Swaby to read the report? Pardon me, the opinion.
Because again, greatly, what's the word I'm looking for? Respected whatever opinion she would provide. And she was also the person on my staff with the most knowledge of the claims. So very anxious to, or very interested, I should say, to hear what she might have to say about David's draft report.
Okay, Registrar, you can close this down. And if you can go to 288 and OD9A, please. So you'll see it at 670. She says his opinion is consistent with mine as to friction testing completed, as there is no industry standard in Ontario. There isn't much cause for concern. Did you share that view that there wasn't much cause for concern?
Did I share that with who?
Did you hold that view as well?
Oh, sorry.
No, I said share, but I meant, did you?
Yes,
did you have that view?
I think that was my preliminary opinion, and then certainly this did nothing to dissuade it.
And when you say that, is that on the causation or the technical aspects of the Trademan report as compared to, say, the strategic implications of the Trademan report on claims?
Yeah, I mean, my concern is that it exists as something that could be called into question and waved around in a courtroom as definitive proof that we had a dangerous roadway. Technically, and I agree that it's inconclusive, and in a perfect world, not much cause for concern.
Okay. I'm going to close this down. Did the Bogosian report provide you with that comfort that you were looking for on the due diligence side for the FOI issue? That is, that the Trademan report was responsive?
Yes, certainly it would have. It would have made me feel better. Yes.
And in turn,
I was. It's not that I would be doubtful in any way of Ms. McNeil's opinion, but it certainly, I had a very high regard for her abilities. Certainly, the insurer wouldn't know who she is. They would know who Mr. Bogosian is. And I was happy to have that secondary opinion.
you'll see in the next paragraph down, you forward Ms. Swaby's response back to Mr. Sabot and said, here are Diana's thoughts, which are consistent with mine. And then there's a redaction for privilege. And then it says, at this point, I think it is incumbent on us to bring in JLT. JLT is one of the city's insurers. Is that right?
Yeah, correct. That's the managing general agent. So for simplicity purposes, they are the insurers.
Who were the people at JLT that you thought, did you have specific contact people there that you knew to raise this with?
Yes. Providing notice of a claim, you would provide notice. You would generally, in writing, provide notice to, at that time, a person by the name of Dino Zenerosa, and you would probably CC Megan Callahan. I don't know what her title was at the time, but I would view her as someone who oversaw a portion of JLT's business of which the city of Hamilton was a part. So she would be interested to get notice of the claim. And it was also general protocol to include the broker, which was a local broker. Then I think they were under the title of Pearson Dunn. They have since changed to Gallagher. They're a Gallagher brokerage now.
Okay.
But the same personnel have been the city's brokers for 20, 25 years.
Okay. Registrar, can we go to page 406, please? So the inquiry has come into possession of a number of documents prepared in preparation for both a council meeting on January 23rd, 2019, which was closed session, and a GIC meeting on February 6th, 2019, which included in-camera sessions. What was your role in preparing for either of those meetings? I direct you to 928 if that might assist.
Yeah, that little excerpt from Ms. Audi would pretty much summarize what my primary role would be in providing information as requested on the claims, the Red Hill Valley Parkway claims, and I would think be at the ready to answer any questions that might come in related to claims or possibly insurance coverage.
Okay. The January 23rd closed session of council included an in-camera presentation from City Solicitor Ms. Audi, where the council was given a heads up about the trade-in report and about the FOI. Did you attend that in-camera presentation on that day?
I don't know if I've tied in what date was that? Sorry, Emily.
It was January 23rd.
And then there was another meeting on February 6th, I believe.
Yeah, and that was the one in which council asked for an apology from staff. It was very long. Mr. McKinnon and Mr. Hurdle presented, Mr. Brown presented. I don't know if that helps to distinguish.
I don't know if I've merged those two meetings into one. I certainly was at least one. And if I had to pick one, I would say it was the February 6th one. It's quite possible I was at both. I certainly, I would remember if I had to speak at either, and I didn't have to. So there's that.
Okay. I am going to ask you some questions about the meeting that you recall attending. I'm going to save those until the period of February 6th rather than January 23rd.
Okay, sure.
Registrar, can you go to 423, please? You see at the bottom, the underlined portion, Mr. Bogosian emailed Ms. Audi an updated signed opinion in this matter, which we call in the inquiry documents the final Bogosian opinion. We don't have any electronic evidence to suggest that it was forwarded to you, and you in fact rely on the one that you received from Mr. Sabot on January 8th in your subsequent dealings with others. Do you recall, did you receive a copy of the final signed opinion from Mr. Bogosian via one of your colleagues?
I would be surprised if I didn't, but I can't tell you that I recall receiving, here's the final draft.
Okay. Oh, I'm seeing the time. It is 3:15, 3:16, which is usually the time for our break. I have just a few more areas to cover, but I would think it would be an appropriate time for a break, just for everyone's comfort. Does that make sense? Also,
Like
we
a
don't
15-minute thing?
Yeah. We'll take 15 minutes and return at 2:30. 3:30.
3:30.
3:30.
Thanks.
Commissioner, may I proceed?
Yes, proceed.
Thank you. So before the break, you had said that you recall attending a meeting with counselors and perhaps attended more than one. At the February 6th closed session meeting, Mr. McKinnon, Mr. Brown, the auditor, Mr. Hertel from communications all presented. Do you recall being there for those presentations?
Yes, I do.
What do you recall about the that session?
You know, my general impression.
Yeah.
Well, I'm not someone who was who regularly attended GIC or council meetings. So, you know, I didn't have a lot of experience to draw on. Generally, I was there 2, 3, 4 times a year, maybe. Certainly, there was an air of tension. You could tell the senior staff involved, who were all veterans of being at council, were tense and nervous, anxious, whatever adjective you want to use. And you know, that's my most definitive memory, is one of palpable tension.
Okay. And what do you recall the reaction of the counselors was to the disclosure of the existence of the Tradewin report?
I would say it was reactionary. I would say, you know, having been around the city for 20 plus years, I wouldn't say that I was unsurprised by their response, but you know, I was hoping there would be maybe a more reserved, thoughtful response. Let's take in this information and consider it. But to my interpretation, and I could be wrong, this is just my interpretation, you know, that the narrative turned very quickly to, you know, who can we blame for this public embarrassment, and how can, and I'm not saying all counselors, but certainly the most vocal ones, you know, how do we distance ourselves from the staff who may or may not be responsible for this, what's being perceived as a massive public embarrassment?
Thank you. I'm just going to go back to the day before that meeting. Registrar, can you bring up OD9A pages 445 and 446, please? Thank you. So these, much of this is underlined just because it was new information to, so it's a little hard to read, I find, but you'll see there is an email from Mr. Sabot to Ms. Audie, and it's quite lengthy. It starts at the middle of page 445 and goes on to page 446. Registrar, I'd like you to pull out the second last paragraph of that email on 446, please. So this is Mr. Sabot and Ms. Audie are talking about the planning for the following the following day, saying I assume David will be cover liability issues. And then the second sentence is, note, John has said the insurer has not been advised, but the broker knows and has recommended to let the situation develop. Is that your recollection that you advised the city's long-term broker who recommended that the situation develop before contacting the insurers directly?
Well, certainly that's my recollection now as I read this. In my recollection, I would have thought that the insurer had been notified previous to the council meeting. I don't specifically recall having that. Certainly, the broker is a woman by the name of Linda Papadopoulos, long-term broker for the city, and certainly I would have been very comfortable talking to her about it. And while I don't have specific recollection of her saying this, I would say that it's more than likely accurate.
Okay.
And I was satisfied, advising the broker if it really came right down to a coverage question, I had covered off that part of the requirement, certainly by discussing the topic with the broker.
Okay. Registrar, can you close this document and go to 10A, please? And while that's coming up, do you recall having any discussions with Mr. Sabot about the prudence of not contacting the insurer until after the trade-in report was made public?
No, I don't.
Okay. Registrar, can you go to page 48, please? In paragraph 102, you received a copy of Mr. Bogosian's draft opinion from rico@cho.ca. Do you know who Rico, what that is? That email address is?
No, I don't. No, sorry.
That's okay. I'm going to skip down to paragraph. Maybe I'll just actually stop there. Is it possible that's like just a scanning thing that gets?
I was just going to say someone must have scanned it and had the ability to send from the scanner.
Okay, I thought that might be the case.
No one named Rico.
Okay, not at COH, which I think is City of Hamilton.
Yes.
So going down to paragraph 104, Viano.
Chalia is how we pronounce it.
Chalia. Is that the individual you were mentioning before as someone who would be one of the people you would report to?
He was with Frank Cow and Company. So they were on coverage for the city at the time the Red Hill was built up until 2011. So their concern was really retroactive in keeping with our concern, that the discoverability concern.
Do you recall having a phone conversation with him before he sent you this? Because it starts off with, can you do us a favor and advise if you have any claims still open related to this period? I'm just wondering whether as a result of the media coverage, he reached out the following day, or if you reached out to him.
It's very possible that, I had a good relationship with Viano, and he would have been one of the few people still around at Frank Cowan that I would know. They had, from our time with them, they had a lot of staff turnover. So it's quite possible either myself or Diana would have called and said, this is coming down the pipe, but specifically, I can't say.
Okay. If you go up to paragraph 103, you also reached out to Megan Callahan, which I think you mentioned earlier, from JLT, attaching the draft Bogosian opinion. When you say, as per our discussion, is David's opinion. Was that the first contact that you had with JLT? Looks like there's a discussion ahead of time, but was that discussion the first contact you had with Megan Callahan?
I would think so. And I don't know when that phone call or discussion would have taken place. Most certainly would have been a phone call. I don't know when that would have taken place, but this sounds like the inception of communication with JLT.
Okay. Registrar, can you go to page 64, please? And can you pull up 65 as well, please? So you'll see the next day that you emailed Ms. Callahan and L. Papadopoulos at Pearson Dunn, which I think you might be your broker, and some other individuals at JLT and Ms. Swaby, copying Mr. Sabot, about a conference call with them, setting out 3 points, which are the top of page 65. You recall that?
Yes, I do.
Okay.
I don't have very clear recollections of it, but I do remember, orchestrating or organizing a conference call.
Okay. The following day, you'll see on page 65, paragraph 150, Ms. Swaby forwarded to you an email chain between herself and Mr. Moore and Ms. Crawford, in which Mr. Moore circulated a copy of the trade wind report in August of 2017. I suggested I would come to this in due course. Registrar, could you pull out paragraph 150, please? So she says, just as an FYI, as shown below, the public could have accessed this report long ago before the media attention. And so this is February 14th. By this point, after the public disclosure, did you know from Ms. Swaby that she had had a copy of this report as early as May 2018?
No, I don't think I would have. I don't specifically recall thinking that and reading this. It doesn't, I don't interpret it as such. I think how I interpret it is now at this point, she is aware that the report did exist and in theory could have been accessed probably as far back as 2014 had someone known about it.
Registrar, could you go into this document? It's 54606, please. So I think it actually might be useful to just actually see the whole document. So in August of 2017, at the bottom, Mr. Moore sends the report to Ms. Crawford. And then in May of 2018, Ms. Crawford emails back Mr. Moore copying Ms. Swaby. And from this document, you can't tell if there's an attachment or not, but it does say we're in the process of preparing the affidavit documents. We likely need to produce a copy of this report in the city's affidavit documents. And then Ms. Swaby sends it to you. And in the top email, there is the attachment listed. So it's a forward, and that's the trade wind report. And so I don't know if that helps with the analysis, but again, I'm really just trying to understand, maybe I'll ask it this way. Did you ever come to understand that Ms. Swaby had a copy of the trade wind report as of May of 2018?
Well, I guess I did on February 14th of 2019. But I couldn't say specifically that I knew in May or any point after, up until seeing what she forwarded to me in February of 2019. that she was aware of the trade wind report.
Okay. And you don't have any recollection of having discussions with her in which she conveyed, oh yeah, I got that months ago. I'm just connecting it to this circumstance.
Not specifically, no.
Not generally either.
No, I mean, Diana was, she would often storm into my office and rant and rave about a lot of things, but I certainly don't recall her ever saying once, post November 2018, saying that she knew about the report previous to November 2018.
Okay, thank you. Just give me a moment to check my notes. I think I've covered everything. Thank you. Those are my questions.
So we're not going tomorrow?
There may be questions from other council.
So I need to be available.
No, you need to just stay for the moment. And
I'm sorry.
It's okay. I know it's been a long day.
Okay.
Commissioner, I understand that both the MTO and Golder had reserved 5 minutes. I've not followed up with them since.
Okay.
Good afternoon. I can confirm we have no questions.
Okay, so Golder says no questions.
Good afternoon, Commissioner. I confirm we don't have any questions as well.
Okay, thank you. Mr. Mishra for the city.
Good afternoon, Mr. Commissioner. I just have a couple of questions for Mr. McLennan.
Okay.
May I proceed?
Yes, please proceed right away.
Thank you, Mr. Commissioner.
Before we lose Mr. McLennan.
Mr. McLennan, you were asked about your knowledge of anecdotal commentary about the Red Hill Valley Parkway being slippery. You had previously testified that you were aware of some anecdotal commentary and or water cooler talk, but you did not know when you learned of it. Based on your experience and knowledge of the claims history on the Red Hill, did you have any concerns with respect to the safety of the Red Hill?
No, I didn't, in as much as I had extremely high regard for the people who built it and for the people who were responsible for maintaining it and monitoring it. As I've said before, I'm not scientifically inclined, but certainly I knew Mr. Moore, as a highly regarded municipal engineer, and he had the respect of the city manager, the then city manager, Chris Murray, who I had the utmost respect for. And I would say the same about the GM of Public Works at the time, Jerry Davis. So if Mr. Moore had their trust, he certainly had my trust. And, it also occurs to me that unlike many other assets that I'm asked to consider at the city of Hamilton, the Red Hill Parkway is one that I am very familiar with, as opposed to claims that we have for sewer backups or people falling off cliffs at Albion Hills or water main breaks or police excessive force claims. This is something I am quite familiar with. I drive it, I've driven it hundreds of times, probably once a week, and never felt that it was unsafe. Yes, I acknowledge that it requires a person to be driving defensively and with the level of awareness that you should always be driving with. And if I had one concern about the Red Hill Valley Parkway, it would be the fact that it's quite clear in my travels on the Parkway that your average driver is not inclined to drive defensively or drive in keeping with conditions or posted speed limits.
Understood. So if I have that right, I take it from that answer that if somebody is driving in accordance with the rule of the road and in accordance with the conditions, that in your view the road was safe.
Unequivocally.
Perfect. Thank you, Mr. McLennan. Those are all of my questions.
Thank you.
Okay. Ms. Lawrence, nothing further?
No.
Okay, then, Mr. McLennan, you are excused,
Thank you.
and you're not required tomorrow.
Okay, thank you very much.
Thank you for attending and spending the day.
You're welcome.
Testimony. Appreciate
Thank
it. The rest of us will stand adjourned until 9:30 tomorrow morning. Thank you.
Night, everyone.
Thank you.
Bye-bye.